Hello, I am praying for the listing of the my application for interim bail.
What is the urgency?
For urgency is
When did we admit?
in 2022, man. And he is already in jail for more than 10 years.
Not to be clear.
Main matter is coming in 24.
He knows about it, not to be deleted.
This case, the petitioner has paid 32 lakh rupees towards permanent.
What is the urgency, sir?
And
Matters listed?
not listed in that.
Sleeve granted matter.
Leave granted है urgency.
Thank
you. Thank you, sir. Thank you.
Item
My
1.
lord, may I please, my lord, may I mention, my lord, one matter, my lord. My lord, one matter was listed on 25th August, my lord. On that day, my lord, my lord, can listen, my lord. On that day, my lord, I was hospitalized. Therefore, I requested one of my friend to adjourn the matter, my lord. But my lord has, while dismissing the matter, my lord, imposed 1 lakh cost, my lord.
Yes, we have deliberately, not because of your absence.
My lord, I am so sorry, my lord.
No.
My lord, the petitioner is poor Adivasi person, my lord. He has annual 50,000 income, below 50,000 income, my lord. I have.
It was perhaps to the best of my.
I apologize, my lord, on that day, my
No,
lord.
it is not. Cost is not because of your non-appearance. No. He never imposed cost.
My lord, my friend was applied,
argued.
but she could not apprise the matter properly.
It was argued, sir.
My lord, kindly appreciate, my lord. This is small matter, my lord. Kindly appreciate, my lord.
This bench does not impose cost at all. But
my lord, I know, my lord, my lord is very well judged, my lord. My lord, kindly appreciate, my lord. My lord, the petitioner has
move an application.
Please, my lord, I will move that.
We'll see.
My lord, kindly appreciate.
We'll see.
Item 1.
Yes, sir.
But this is directed against the conviction under P76 and
Yes, tell us.
Yes, the sentence of 10 years, but 6.5 years is already undergone.
Yes.
But it is my specific defense that I have been framed in this because I had a quarrel with the family of my lord the complainant. One of the main reasons, my lord, your lordship, you should notice is the evidence of the doctor.
Yeah, we have seen that.
Yes.
You've been behind bar for 6 years.
6.5 years.
Out of 10 years.
Out of 10.
Yes, what do you say?
Lordship, granting leave was
Bail.
Lordship.
6.5 years already undergone.
Yes, I am not opposing the bail, but this is a criminal appeal.
Yes.
So what do you want? We have not granted leave thus far.
Lordship.
What he probably wants to say that if leave, your lordship will have to grant leave and hear it finally.
Years.
Lordship.
Minimum sentence is 10 years.
Yes. 10 years. This is a criminal appeal. So if Lordship wants to hear it on some day, Lordship may grant bail at 6 years, more than 6 years is done.
What we propose to do is, we'll grant leave and list it in the minutes. You may perhaps have a good.
Lordship.
Kindly grant me bail till at least till 6.5 years is my lord out of 10 years.
No, it is not out of 10 years.
It is minimum is 10 years.
Minimum.
Correct. The sentence about it is 10 years.
We are granting leave and we'll fix it for hearing.
Your lordship are aware our matters are not reaching. I am only praying for bail, my lord, for hearing, my lord, any date suitable to
Matters are reaching, lawyers are not reaching.
In this court, you can't say matters are not reaching.
Once your lordship grants leave, my lord, we don't know before which court, my lord,
Leave granted. We are granting bail.
Lordship, she is for the complainant. You have, Lordship had appointed
Amicus.
Yes.
Lordship, this is the concurrent conviction by the below courts.
What else? You're an amicus, yes, please.
Lordship, according to section 29 of POCSO, create statutory presumption of guilt once the foundational facts established by the prosecution. And in this particular case, the prosecution has well established the foundational facts. First, according in the commission of offense, which is corroborated by petitioner witness 3, with the identity of the accused, with the testimony of the victim, corroborated by the petitioner witness 3, who was minor at the time of the incident, merely 7 years before. However, the accused has accepted this fact that he was residing on the first floor of the building, same building.
Yes, continue.
Whereas the accused accept by making the false and fabricated story that there was a conflict between the petitioner and respondent number 2 regarding the poor food quality. He is making this story, and he is not letting any evidences to discharge the burden upon him, my lords.
So very glad that you have prepared your story. Sorry, sir. We are not granting. We are not granting it. Leave granted. This was it. He's argued very well.
Good for that.
But, no.
But
See,
your lordship.
gentlemen, just listen.
Yes.
We were ourselves in doubt. Have you not seen twice we were conversed to do or not to do?
Yes, yes.
She has invited our attention to the fact that it's a 7-year-old victim.
No, she was 14 and a half. He's wrong.
No, victim was 14 years old. The prosecution witness, her brother was 7 years old at the time of incident.
Wrong. We are granting leave granted, list in November.
Great.
Grateful, my lords.
But record will have to be called immediately, otherwise.
Record be called for immediately. Digital copies be transmitted, be supplied to the council. Digital copies be supplied.
Please, your lordship.
One thing, sir, which will come in your way
Yes.
is that you have not led any defense. See, why we are telling you, we have read the brief.
Correct.
What is weighing in our mind is this only, that the doctor's statement is perhaps in your favor.
No internal, no external.
Sir, just 1 minute, you are not allowing us to, please.
Yes, yes.
Doctor's statement is perhaps in your favor. But the testimony of the victim, the mother, perhaps, and the brother, how do you overcome that
Yes.
in view of the law laid down by this court?
Yes.
That's all you are prepared on that.
There are several discrepancies in
Thank
the
you.
evidence.
That's what you are. Thank you.
May I please, your lordship?
Yes, please.
Lords, in terms of the last direction of my lords, I have filed a supplementary affidavit spelling out all the orders and filing all the order sheets. Some were in Urdu, so I have also filed a translated copy and typed copies of the same.
So he is to be blamed for delay.
Not only he, my lords, the other accused persons, because out of 42 effective hearings after framing of the charge, out of 26 hearings have to be adjourned because on one of the other accused was not present. Neither an exemption is filed and NBWs were to be issued.
Who's for the petitioner?
I appear for the petitioner, my lords. My lords, I appear for the petitioner.
Yeah, yes.
My lords,
We
too
want to
small.
know what is the reason for delay. Prosecution is not the reason for delay.
I bow down. My lord, just 2 small points if for your lordship's
3
consideration.
kg heroin, 3 grams,
8 grams, my lords,
8 grams heroin.
and 20 gram poppy.
Coffee.
My lords, in respect of the sentence, the charges that have been framed against me, except for section 27A, carry a maximum term of 10 years. On account of the charge framed under section 21A, the sentence that.
You ask your co-accused to fully cooperate. You'll say the trial is expedited.
My lord, just 2 small points, my lord. Just 2 small points for you. Number 1, my lords, out of all the hearings, and there's a very helpful list that my learned friend has himself produced in the supplementary affidavit.
Correct.
As per this list, there have been a total of 11 times when all the accused were present, but the prosecution witnesses were not present, because of which the trial had to be adjourned. I can give the dates to my lords.
Just hear the order. We have used the supplementary counter affidavit filed on behalf of the respondents, annexing the order sheets, the trial. Sorry. we, of the considered view, that interest of justice will be best met with the disposal of the present petition in the following terms. A, the hearing in the appeal, the trial is expedited. The prosecution shall ensure that the prosecution witnesses remain present on such date which may be fixed by the trial court. For as we notice that on 11 such occasions since the commencement of the trial in the year 2021, there have been 11 times when the witnesses were not present. Even though the accused were present, all of the accused were present, the witnesses were not. See, that's all. Thank you.
My Lordship, may kindly just, in the event the trial does not progress for reasons beyond my control, would your Lordships kindly permit me to approach for bail again?
Liberty granted to the petitioner to approach the court should the trial not progress.
Grateful.
Because, not because of their faults.
Not progress, whatever it is.
Please, my lords, only my lords have said trial has begun in 2021, it has commenced in 2022.
2022.
I am deeply grateful, my lords.
Item 3.
Please, Your Lordship.
This is against the cancellation. My anticipatory bail has been cancelled. Now see the facts and merit of the case. There are cross complaints only at the relevant point of time. My mother was a sarpanch, and the grudge was that her son has not been appointed on the compassionate ground in the Gram Panchayat. Therefore, this crime has been registered against me. And prior to that, my affair is there.
Both the conditions.
Lordship, my daughter is having a bone marrow, so I have to travel.
But see, gentlemen, you had to just tell the court that sorry, sir.
Even there was some error because charge sheet was already filed, but while passing the order, it has been noted that after filing charge sheet, 3 months. So, but at the time of passing that order, even charge sheet has been already filed. But see the merits, my lord. See the fact. This is all vindictive. And I am working as a Gram Sevak. I am in government service.
So influential, your lordship.
Mother is my humble request, my lord.
Sorry.
Why should you even interject?
Sir.
Have you called upon me, sir?
Sir, yeah.
So my humble request, Lordship, kindly see the holistically all of the things, because I am working in the government.
Why is you violated?
So, they have this after the impugn order, after the order granting bail, there was some function, and that's why I attended marriage ceremony. There is no investment, there is no.
Is an offence under the SC/ST Act?
Yes, your
Lordship, it is not made out, my lord, because it has been misused. I will read certain paragraphs.
What was the condition?
No, not made out. Therefore, you were granted anticipatory bail.
Yes, ma'am.
Now you have violated.
What was the?
Again, I will read certain
What was the
paragraphs.
condition there you violated?
Not to enter into that particular village.
And what was the charge against allegation against you?
That
He incited.
yes. I will read that. Lordship, this is not a case of cancellation. May I read certain paragraphs? I will read and I will leave it to Lordship. Lordship, may kindly see page 56. I will read from para 6. My lord, this is the order which passed granting bail. May I read, my lord? Para 6 at page number 56. Perusal of investigation paper revealed that informant is pressurizing. Complaint at 2 o'clock, and then evening they have lodged this complaint because only reason was that my mother was a sarpanch at relevant period of time, and her.
Why did you violate the condition is what we are saying, because it amounts to not.
I will compensate, my lord. I will
not only violate,
cost on me.
Influencing the witnesses.
No, that is allegation. With great respect, that is allegation. See the vindictive character, my lord, how they are behaving. They just want to rope me into this, my lord. I will compensate. I will pay some cost.
Not the.
I do agree. I understand what is falling from your lordship. Lordship kindly appreciate, because he is a government servant and his daughter is having bone marrow. He is a donor.
Is when your daughter is suffering from bone marrow?
So I have placed all the documents as additional documents.
Just
I will just point it out.
Yeah, just 1 minute. What do you say?
Your Lordship, twice he has violated the
Since
condition.
20
Even Your Lordship, kindly see his complaint he has been made.
2020.
He has tried to influence the people against me, Your Lordship, to create a law and order situation in the city, Your Lordship, the place. And his mother is Sarpanch, he is an influential person, Your
She
Lordship.
was not a mother, Sarpanch now, my lord. He is not a Sarpanch now, my lord. And I have not influenced. This is all allegations, my lord.
Thank you, sir.
Oblige, Your Lordship.
So what? So I am ready to compensate, my lord. Lordship may kindly impose cost, my lord.
Cost is not the solution, sir. Thank you.
Item
I'm
4.
obliged.
Please, my lords. On the last occasion, my lords, I had pointed out that the main co-accused had been granted bail. Your lordships were then informed that there were antecedents. I said that the antecedents were all cases which were subsequently put on me after my arrest. I have now filed a rejoinder affidavit which shows that in all those cases, though the cases were pending earlier, my name was not there in the FIR or in the charge sheet. After my arrest, they've just added it so as to keep me. I've got bail.
Milord's not like that, Milord, that we have just added him, Milord.
I know, bail.
More than 3 years.
5.
Lordship, permit me, may I mention one request only? I will surrender and the trial court may consider my bail urgently, my lord. Expedited, at least that. On the same day.
Just for justice, will be best met with the disposal of the present petition on the following terms. We'll just call the other side.
I have already informed them outside. They are well aware about this. I was just informed.
The petition shall surrender within
2 weeks, my lord.
within 2 weeks from today. That's all. As and when the petitioner moves an application for grant of regular pay, the court shall consider the same on its own merits, expeditiously on its own merits in accordance.
Because charge sheet has been already filed on
He
the
said expeditiously on its own merits in accordance with law.
on the same day because he is in government service, my lord. So, Lordship, that is intelligence because this is a fit case of antecedent.
Expeditiously on its own, we have said that.
I'm okay. On the same day, if it will help me because otherwise I will be suspended from the service.
Hold on. Same, expeditious.
On,
Expeditious.
I'm okay.
We can't say same day, now please.
Yes.
You understand? Supreme Court saying same day means a lot.
I'm okay.
Please, Your Lordship, this is after this matter. The state has to file wakalatnama.
Your Lordship, we were served on last Saturday, so
Yes.
we have filed the memo, but it has not been came on record.
Your Lordship, I also have to file the proceedings of the trial court to show that there is no delay from my side.
Correct.
Your Lordship, this lady will file it.
As paid for within 1 week. 1 week you file,
Yes, sir.
under 1 week list on dash. Needless to add, in the pleadings it shall be, in the counter affidavit, it shall be, state shall inform the stage of trial and as to whether there is any delay accountable to the president.
I'm deeply blessed.
Obliged.
Item 6.
May I please, Your Lordship? Earning notes in item 6, there is a huge delay in approaching the lordships.
Doesn't matter, you argue on that.
Your Lordships, are very exclusive legal notes. Notes the co-accused has been granted regular bail by the High Court notes.
Yes.
And notes the allegations are recovery of 351 liters of illicit liquor outside the house.
Notice. Notice.
Lord, so I'm appearing for the state. I accept the notice. I will count. I will count.
As an under trial, he is in jail since December 24 months. Material witnesses have been examined as on date. My lords, in between, there was a death in his family. My lords had granted interim bail. He had not surrendered within the time specified by this court. My lord, now on regular bail, as an under trial prisoner, my lords, material witnesses have been examined. he's not directly connected to the crime, my lords. The allegation is against the other co-accused, whom they say they had an enmity with the deceased.
What do you say?
Because the recovery from him is of blood-stained clothes and the motorcycle that was used in the incident.
But he is not the main accused.
Because he's been named in the statements, Your Lordships. As the statement of Anoki Lal, Milords, although it's a 161 Milords, the trial has commenced. PW3 has been examined. He has named him.
Recovery of blood-stained clothes of the deceased or of himself?
That is not clear, Milords, actually. I'm sorry, in the disclosure.
The recovery is consequent to memorandum.
Yes, yes.
Where is
pursuant to the disclosure?
Where is that memorandum?
Yes, yes. Page 30, Milords, Your Lordship will have.
30?
Yes, Milords, 30.
Yes.
Your Lordships comes to page 32, the last few lines. And as soon as I held Roop Singh tightly, Roop Singh is the deceased, Milords, tightly on the ground, my brother-in-law, who's the co-accused, took out the lightning bulb and made it dark and kept the bulb nearby. After that, my brother-in-law Shiv Narayan slit Roop Singh's throat, cut it in half with a sword. The sword has been recovered from the co-accused. We both ran away from there with the mobile. Then I dropped my brother-in-law Shiv Narayan at his house and came to my house. Later, we both kept hiding here and there. The next night, we both reached my in-laws' village, Turania, by bus. Then last night, when we both were running away from there, the police caught both of us. Motorcycle is standing at my house. The motorcycle is the vehicle by which they had come to the field. And the clothes worn at the time of the incident. Now, Milords, whether it belongs to him or the other guy, it's not.
You're holding him.
What is your name?
Milords,
Dharmendra.
He's Dharmendra Bakuri. Accused number 2. Milords, may just see the statement of the witness, how he states, Milords, which was recorded by the police at page 45, Milords. This is Anoki Lal. He is the alleged eyewitness to the incident. If my lords may have at page 46, last 6 lines, my lord.
Yes.
How he states, my lords, starts from some unknown persons. These persons were well known, my lords, in the village. Everyone knew each other. Some unknown person has murdered my Roop, it should be my brother, my Roop Singh, by hitting him with a sharp weapon. I was very sad to see the dead body of so-and-so. Therefore, I could not give any information about the 2 persons whom I had seen on motorcycle near the farm at night. But they were Dharmendra and...
He is already examined.
Now he is examined.
PW3 has been examined.
Anoki is PW3.
He is being examined.
Where is the deposition?
The deposition is not on record, Milords. We'll place it on record.
It was subsequent. We'll bring it on record.
Has it in the deposition, has he named you?
It's now in the deposition because
he has named
it's
you.
An afterthought. It's an afterthought.
Thank you. No, please. Very fair.
Item 8. This item 8 is also coming after notice, Milords, except the confessional statement of co-accused in another case, Milords. There is nothing against me. And Milords, I got merely, Milords, considering the antecedent, Milords, rejected it. Nothing, Milords, please see the impugn order, Milords.
Yes.
Not named in the FIR, nothing, Milords. In a confessional statement of co-accused in another case, Milords.
Who's there? Yes, what do you say?
Your Lordships, we have filed a counter on Saturday.
What do you say in the counter?
Your Lordships, we have listed the antecedents there.
Is yours?
5 cases. 5 antecedents.
4 cases. 4 cases as per their own counter.
Your Lordship, 5 antecedents were disclosed before the High Court. The state's information that we were able to retrieve only 4 antecedents.
All 379?
Your Lordship, some are murder as well. Your Lordship must see
No.
para 15, Your Lordships.
Page 6, Milords.
Your Lordship, 2 similar antecedents of the county, Your Lordship, as is this present case.
First and 4 is 3110, that is.
Yes, Your Lordship, and in fact, Your Lordship may also see para 16, wherein we've stated that as the investigation is still undergoing, we require time to also recover the articles from the informant and his companions from the
Have you given a bail?
No, this is a regular bail.
This is regular, will look 7
How
months.
can the investigation be pending?
7 months will look, and
Your Lordship, some of
only
the things have.
charges have yet
absconded.
not changed, look, only charges.
Investigation may be pending where the other accused, but if it is pending 6 months, he
No,
must have been
look,
released
look,
after 90 days or 60 days.
charge sheet has been submitted, will look.
But there is a pattern. I don't know whether false implication or you are a criminal, because everything is of November 24. October, September, October, November 24.
Looks, this is again strange thing, looks, I did, look, since your lordship raised it, looks, what has happened, looks, in all the cases of that area, looks, my name has been, look, this is, your lordships have been there, look, this is how, looks, to solve the cases.
That
This
usually
is,
happens because
looks, similar, looks, I'm so sorry, looks, prior to that, nothing, looks, thereafter nothing.
because people like you are active in a particular area at one point of time.
Looks, here also,
Since they are mission in one area and then move to some other area.
please appreciate one
It is
thing.
how they operate.
Here also, Milords, nobody has said anything. Milords, a co-accused, maybe Milords rival, co-accused in another case, Milords. In another case, Milords, there is a confession.
The rules, the counter affidavit filed on behalf of the state. If you use the counter affidavit filed by the state, copy thereof handed over to us in form. Having considered the matter in its entirety, we have the considered view that interest of justice was best met in the disposal of the present petition. The following terms: A. The petition shall be enlarged on bail on such terms as be fixed by the trial court. B. The petitioner shall report to the concerned SHO, police station, on every Monday between 11 and 12 till the time the testimonies of the material witnesses not till the time trial begins. Trial begins.
So great, Your Lordship.
No, please, this is an off notice. It's time for the complainant notes. The state is, I believe, served. Accused Lords has not been served, Lords. So I request if the service could be done through the concerned SHO.
Okay.
Look, this is a case of cancellation of bail.
Yes.
Undertaking was given to the Honorable High Court.
Correct.
Settlement entered 29 lakh.
Where is the respondent?
Respondent.
Fresh.
Lords, he remains unserved.
Let fresh steps for service of unserved respondents be taken within 1 week. Service to be effected through the concerned SSP.
Only respondent number 2, Lord. Respondent number 1 is served.
Unserved respondents होगा ना?
Okay, there's only 1 left.
जो भी है unserved respondents.
Obliged.
Your Lordship, in this case, Your Lordship, I just see the notice has already been issued by the.
Yes, yes.
Your Lordship, the other co-accused has already got bail at the before arrest, Your Lordship.
You are there. What do you say?
My lords, the only saving grace is his prolonged incarceration, and none of the witnesses have been examined. The only saving grace. Grateful.
You want to file now?
Yes, and the prosecutors has not been served. R2.
Affidavit by the state be filed within 2 weeks. Then service upon respondent number 2 be effected through the concerned SSP. Better.
Immediately after doing
Steps within 1 week. Within 2 days, 2 working days.
Item 12.
Please, my lord, the interesting part of the prosecution case is.
What do you say?
My lords, the two witnesses remain to be examined. The date is fixed on 24th of September, my lords. We will finish the evidence, my lords.
One of the person who loaded the consignment, they had been exonerated, and the person who is supposed to receive the consignment, he has already been released on a bail. Page 124, my lord.
My lords.
Everybody.
My lords, 5,000 bottles of cough syrup.
Yes, for me.
My lords, only two witnesses remain. My lords, 5,000 bottles were recovered from the exclusive possession of the
23 is behind bars.
My lords,
Then prosecutor states that only two witnesses required to be examined. We expedite the trial. Petitioner undertakes not to take any adjournment.
Next.
We cooperate not to take.
Please, sir. The evidence for me appears to be weak. Evidence for the other co-accused there is last seen. As far as the other co-accused is concerned, that's one. Second, the medical evidence also is inconclusive.
But you have been behind bars for how long?
5.5 years.
302, 5.5 is. An appeal is pending, that's all what we can do.
Appeal is of 22. Appeal is of 2022. And there the Lordship knows appeal from 2010. And the evidence was for me. The last scene is with the other co-accused.
Notice.
Grateful.
Your Lordship, as per the custody certificate, 31st March 2025, sir. I mean,
10 years.
10 years, 11 months. 10 years, 11 months.
Notice. Petition notice.
Lordship, maybe I may pass a judgment passed by this honorable court. I may get benefit of this judgment, Your Lordship. Saudhan Singh judgment, Your Lordship.
How to be a petition notice?
Well,
not today, huh?
oh,
Not today. Keep it from this.
obliging.
It's a fresh matter, huh?
Yes, Your Lordship. It's a legal aid matter, sir.
It's a fresh matter.
Yes, Your Lordship.
Ref legal aid matter.
A delay may be condoned, Your Lordship.
Delays.
Obliging.
To appear for the petitioner.
Yes.
Look, Malle Shappa is the father. And Basappa and Chaitra, the two petitioners, are people who came later.
I got confused with the name, so I request my lord to take over.
Look, 23, if I take your lordships, the Shawcos notice says the father, Malle Shappa, there are allegations against him. And the Shawcos notice says to the both of us, the petitioners hearing, to pay the amount. We say we'll pay the amount. The allegation, the sum and substance, if you take it also, it's against my father. The allegation.
Forgery and fabrication is of documents of financial assistance of 3.4
That's all true. That's all against my father. Even the Shawcos notice and the FIR, the allegations are prima facie against my father. My father passed away, they registered an FIR. Now today my custodial interrogation may not be required. That's my only submission. Because these are two directors who came later, the son and the sister-in-law. They are saying we'll pay the amount, the entirety of the amount. Please don't custodially interrogate us. Because we don't, there is no allegation.
When were you inducted?
We were there. But even the FIR does not say anything
They are
about.
also guarantors, Manoj.
Yes, guarantors, that's what matters. If your lordship give us protection from custodial interrogation, we'll completely cooperate not only with the investigation, we'll entirely pay back the amount. That's what we have said.
Will you pay?
Yes.
Okay. Under instruction submits that petitioner, innocent petitioner, who was the guarantor, is ready and willing to deposit a sum of rupees 3.24 crores. You are ready to deposit, no?
My lords, the amount would your lordships leave it. My lords, it might be even more than 3.24 crores because that's
this you pay, no?
I leave it.
This you deposit.
I leave it at that.
The entire amount which is more than 3.25 crores, shall
That's-
be.
That also, I don't
You are
know.
contradicting now.
I leave it at that. I leave it at that. Look,
Entire amount, including which is more than 3.24 crore share.
I only wanted to be fair because.
Shall be, no, very good. Shall be deposited with the Shri Mahayogi Lakshmana Cooperative Bank Limited, correct?
Yes, ma'am.
Correct. This, the petition shall do within a period of 2 weeks from today. And full stop. We clarify that such deposit shall be without prejudice to the respective rights and conditions of the parties. Then, intent way, you file your.
And for the complainant notice has to go to the state.
You are a party here.
Yes, R2, page 7.
R2 accepts notice to the state, return. That's the in addition.
Protection will also be.
It can be accepted.
Most of it.
Proof of deposit being filed by the.
My lord, on item 16, I am seeking.
Yes, please.
My lord, in item 16, I am seeking compassionate appointment, my lord, which has been rejected on the ground which has not been fully proved that these certificates of my college, of my school certificates were forged. My lords, I passed out in 1996. There are allegations and purported findings that the school is shut. However, this inspection was undertaken only much after, my lords.
Just 1 minute.
Yes, ma'am.
This.
Most obliged, ma'am.
Your Lordship, the amount mentioned in the salary slip is not believed, Your Lordship.
Notice.
Delay. No, sir.
May it please your lordships. Sorry, my lord, I could not be there in the court today.
Yes,
my
sir.
lord. Yes, here, my lord. I am, my lord, not objecting to the share which is given to the respondents, my lord, who were plaintiffs in the earlier suit. All that I am saying that my property, which I had purchased under a sale deed, that may be excluded from the partition in the final decree, which is being sent for execution to the Tehsildar now. I am placing my claim, my lord, on the basis of title which I had acquired.
No, we are
under
not
the-
interested in your claim.
I'm
You
sorry.
argue, you just meet out.
The High Court has
protected it. It has been dismissed.
Yes, my lord. May kindly appreciate, my lord. What High Court says, my lord, that I have an option to
You
go
were
under
a
order
party in the
21
earlier
to.
suit. Why did you not raise all these? That is the
Because, my
ground.
lord, that claim was
Oust you.
restricted to grant of her share, my lord. Whether she was entitled for partition or not was the question, my lord. That was the limited prayer. Kindly see the prayer which was made in the earlier suit. At page, my lord, 37. She was only claiming partition in the joint family property. I'm not objecting to it, my lord, in this case. All that I'm saying is that
Yes, already.
the High Court, my lord, says that I can go and file an application under Order 21, Rule 97, my lord. But your lordships held that, my lord, it is only the decree holder who can file the application under that section. So, my lord, virtually, my lord, I am rendered remediless, my lord. I don't have any other.
No. You are unnecessarily raising a claim here. And if your SLP is dismissed, probably you may find it difficult before the executive court.
My lord, executive
Para
court.
9 and 10, the court has protected your interest. You
My
avail
lord,
that.
But kindly appreciate, my lord, I cannot, your lordship, in
1 minute
in
more
view-
and will not grant you liberty or neither allow you to withdraw. 1 minute more.
Very well, I leave it to your lordship.
No. Decision is yours, sir. Either you withdraw or be dismissed. Simple as that.
Then your lordship will observe that I
Avail
can.
that liberty. Why should we
Well,
offer? It is already there, observance.
Lordship may observe that.
The court has already observed unnecessarily.
You tell us, you want to withdraw or dismiss?
I'll withdraw.
Please don't.
Let.
Lord will be led by Ms. Naran, seeking a short passing.
Mr.
Ms. Naran.
Mr.
Put me.
Pass.
So this is first appeal, my lord.
Yes.
And my lord, respondent, nobody appeared before the
First appeal,
first appeal before the High Court against.
So good.
My lord, the High Court has reversed the findings without appreciating the evidence afresh.
No, but you want to oust your siblings, that's what it
So,
is.
my lord, in this case, there was a family partition.
Family partition.
And after family partition, my lord, mutation was also done. Mutation was also carried on record.
Family partition on 200.
So, my lord, it was also translated in mutation records. And it is admitted by plaintiff himself.
You want to oust your siblings, sir?
PW1 herself admitted that possession was according to partition. Appeal the subsequent partition they staged in 2009.
Thank you, sir.
So, no, kindly.
There you are, siblings, sir.
You will also get some. Kindly have a look at page 81 for a while.
We have seen that.
Page 81, there is reason finding in respect of succession having entered.
Yes.
Blocked by the
oral partition. How do you prove an oral partition?
There is other issue also.
Thank you.
Succession having entered in 1986 itself.
So, no. Succession. How do
that? Because here the daughters have also came.
So
and daughters come into.
Thank you.
After 2005
Thank you.
Obliged.
No, Vinita Sharma says it will be prospective.
Yes. Yes. She has not examined that one.
Next.
It's based on the
Next case.
Okay.
Please, my lords, the similar matter is the very same judgment.
Same order.
Same order.
Office order.
And
he is also giving it. Take it.
22.
20.
You want to pass over?
Oh, 23, my lord.
22, who said a pass over?
22 pass over. 23, my lord. After 18 years of filing of suit, High Court remands it back to the trial court upon 4 documents being adduced as additional evidence under 41 Rule 27. The power of remand for the High Court is very limited, my lord. This honorable court, at least on 2 judgments, says that when High Court has to remand back to now.
Legally, you are right, but then it's government property.
My lord, it is not at all a government property.
That will be proved.
My lord, Exhibit 94.
You also need evidence before the trial court.
My lord, after 18 years, if it is remanded back, there is no.
18 or 20, my lord. Property will become your government property.
Is my case.
Property is there, property is not.
Property is there. My lord
will not perish. Land will not perish.
I would only request at least a total limit may be set by the.
We'll say expedited. Hearing is expedited. Even though we are not inclined to interfere with the appeal further, but however, we expedite the hearing, direct the parties to cooperate and not take any unnecessary adjournment. We request the court to decide the matter expeditiously and preferably within a period of 1 year. 1 year.
My lord, may I make only one submission? My lord,
this honorable court had issued on 2 Judgment 2023, there is a judgment Sirajuddin would say.
Yeah, we are aware of it. Therefore, we said you have a good case. We told you that.
Wait,
thank you.
Please, Your Lord. Lordship, it's the trial court finding that he does not have sufficient fund. Can I take your Lordship to page 86 alone? Page 86.
Yes. Yes.
In the middle, Your Lordship, it starts with the plaintiff.
Page 86.
86.
वापस करना पड़ेगा. ऐसा वापस करना पड़ेगा. What is the finding by both the courts about the existence of agreement? They say it is executed.
They say it is executed, Lordship.
But finding of fact against you.
But it's a finding of the trial court which says that he does not have any document, nor does he prove that he has sufficient fund even to pay the balance of 10 lakhs also. He is claiming that he has paid 29 lakhs.
Therefore, that decree has not been granted to him.
No, it's in my favor, Lordship. Kindly see page 86. In the
No. 86 is by whom?
86 is the finding, Your Lordship.
By whom?
By the trial court.
By the trial court.
By the trial.
Then thereafter what happened?
Lordship, thereafter.
You are defendant.
Yes, I am the defendant.
Which part of the decree you are resisting?
I'm resisting that
refund.
The document itself is forced.
No, but you are resisting the refund, the order of refund.
Correct.
On what ground?
On what ground? Because I haven't executed such a document.
Both the court has found that the agreement was executed between the parties.
For having paid,
the fund has been, amount has been paid in advance to you.
May I just state this word? For having stated that 85.
How is that finding of fact not borne out from the record is what we are asking you.
Correct, Lordship. For that only I have been trying to point out of page 86.
You will not come to the judgment.
I will come there also.
You will not come to the
No,
judgment.
I'm sorry, I'm coming there.
You are pointing to the finding about readiness and willingness.
Not readiness, in readiness and willingness. He had in readiness and willingness. The court had found that he does not have any he doesn't bring in any document, nor does he have any capacity to bring the sufficient fund. That's what I'm trying to present to your Lordship at page 86. In readiness and willingness. In the middle, your Lordship. The plaintiff has not filed any documents to prove that he had sufficient fund to pay the balance sale consideration either during the period stipulated for performance of the contract or even thereafter. The plaintiff has not assigned any proper reason why he waited more than 2.5 years even for issuing legal notice, even after the defendant refused to perform as part of the contract. My contention is, Lordship, this is a balance of 10 lakh. For a 10 lakh, when the court says you haven't been able to prove that you don't have sufficient, you have sufficient fund, the main part is of 29 lakhs, he doesn't even mention or whisper anywhere in the agreement. But what method did you pay? By cash or by bank statement, or did you withdraw? Where does it reflect? If he proves any document, Lordship, or does he present a bank statement, I rest the case there.
How did you respond to the legal notice?
In reply to the legal notice, I should frankly disclose that neither in the written statement or in the additional statement, I haven't taken this ground. Only during the time of argument, yes, I have done that, Your Lord.
41 is a written statement, sir, and therefore we have gone through it. Thank you.
Lordship, may only to this extent, Lord.
You say you are.
Lordship, only to this extent alone, Your Lordship. Only limited to the extent of interest part alone. Interest part alone now comes to 35 lakhs, Your Lordship. That is 12%, and no court have been considered reduction of little bit, Lordship. Not more than that, Your Lordship.
You have enjoyed the money for all these years.
Lordship, 12% may Lordship may at least reduce to 9% alone, Lordship. I am not asking anything.
Thank you. You are good friend, sir.
Deeply obliged.
Yes, sir.
Please, my lords. My lord, the present case is wrongly listed before this honorable bench.
What?
There is a conflict of interest. In fact, I had written to the registry 2 days ago.
Where is the
here. This is my email to the registry just 2 days.
Where is the conflict?
My lords,
Where is the conflict, sir?
my lords, I had filed a complaint with lawful authorities, which is still pending.
Complaint against either of us?
A certain section of the judiciary.
No.
Yeah, one of the two.
Why feeling shy? You tell us it's me or my fault.
Yeah, my lords, yes.
No, there is a criminal complaint pending
Yes, my
against
lords.
one of us.
Yes, my lords.
Which is that complaint? Let us see. We are not aware. Let hand over one copy of that.
Against me.
Let us see. Please complain.
My lords, the lawful authority has forwarded it to the Secretary General of this Honorable Court for further action.
Oh.
And I had also written to the Honorable President of India.
Complaint क्या है ये तो पढ़ लें. Allegation नहीं उसकी तो.
My lord, the complaint is supported with 100 pages of verified.
1 minute.
No, well, former CGI is also an accused.
Yes, my lords, yes.
DYC, SK, SANJAY, KAROL, Manmohan, they are all accused.
Yes. I am not there.
No, my
Why? Why I am not there?
My lords, the entire complaint is based on my experience before this honorable court. And my lords, it's supported with 100 pages of verifiable material.
What is the nature of complaint?
And what critical that brother has just.
My lords, what happens is I lost my brother to gross reckless and criminal negligence by a fake doctor employed by one of the top corporates in India. I got the doctor and the corporate book and 4 different FIRs lodged in 4 different states. Not an iota of investigation took place in any of the 4 FIRs. My protest petition against the final report was dismissed for non-prosecution.
Why am I making
And my lords, my lord, let me complete my submission. My lords, my protest petition was dismissed for non-prosecution. It was upheld right up to this honorable court. The bare minimum this honorable court could have done, seeing the gravity of the allegations and the evidence placed on record, was that it could have restored my case and I could have gone back to Jharkhand to re-agitate it. This is the bare minimum I would have expected from them.
What is, you come to merits of this matter, Mr.
Yeah, so
what is your name?
My name is Mr. Shishir Chand.
Yes, Mr. Sisir, please argue your case on merits.
My lord,
you are not recusing.
My lords, I have no confidence in this honorable bench.
We have no confidence in you. You please argue. We are not going to recuse this.
My lord,
come what may, we are going to decide this matter.
My lord, still my complaint.
You take whatever recourse you take, you lodge a complaint against anybody. You please come to this.
My lords, I
don't take the court proceedings lightly.
Lords,
Mr. Sisir, please argue your matter on merits.
My lords, I have reasonable apprehension that justice may not.
Forget about that. We are not.
My 2 SLPs
we are not dismissing. Honorable CGI has allotted this matter to us according to roster. We are not going to adjourn this or even pass over this. You continue to argue till 4.
My lords, in that case,
Mr. Sisir, we are warning you.
My lords,
Mr. Sisir,
that case,
I am giving a warning to you. Please argue your case.
I prefer to withdraw my SLP in that.
You have dismissed as withdrawn. Don't take the court proceedings lightly, and don't make allegations like this.
My lords,
we have no faith. We have no faith.
My lords,
as if we are on your mercy.
My lords,
what are you thinking of yourself?
My lords, I say,
what are you thinking of yourself?
My lords, my complaint.
Don't be over smart, Mr. Sisir. I am telling you, you will be behind the bars. Never take this court lightly, or any one of us. I am telling you, right now we will send you. Yes, please call the next case. ये मेरे पे रख लेना.
Lordship, I am seeking pass
More
over.
bus to this kind of.
Yes, seeking pass over.
Why pass over?
You should let.
No, this is another case. Don't worry about it. Don't worry about it. It is over. We are as cool in the other matter, the next matter. Absolutely.
I am led by Mr. Senior, Your Lordship.
Okay. If that is the matter, then.
Oh, please.
But don't do one thing, just in case we dismiss your matter, then don't file a complaint against me.
Notice your lordship is in 25th of August is the connected matter case, lordship is to notice. But I am pressing interim order in this case. Similar matter.
But we did not pass any interim order.
But that matter is a bail, anticipated bail. As per the here, my lord, the FIR itself is, my lord, stay. So, my lord, in a bail order, the High Court was directed that he has to appear 3 days, my lord, and
May I please, your lordship? My lord, counsel for the respondent has some medical difficulty today, your lordship. So may kindly.
Have you complied with the order or no?
No, my lord.
Who's for the?
My lords, I'm for the petitioner in this matter. My lords,
Have you complied with the order or no?
My lords, we are still in the process. I've written multiple emails to the counsel for the respondent, but there's been no reply.
My lord, I'm proxy counsel. She's not well today.
We've written multiple
Kindly adjourn it.
multiple emails.
Let the respondent comply with the order. List on dash. Let the respondent be the parties comply.
Please, notes, High Court notes frames a wrong question of law and admits the second appeal notes. And the petitioner before your lordships are senior citizen. Your lordship expedite the hearing at least. Complete wrong question of law. Yes, sir.
It's an interim
No, you
order.
move an application for correction of the, if you say that the question of law is wrong,
Please,
you get it corrected in the High Court.
lordship may grant me liberty notes, otherwise.
Not liberty.
Because
Seek
it's an
permission
interim order, my lord.
Seek permission to initiate appropriate proceeding in accordance with law. Does not present seeking liberty to initiate appropriate proceeding.
Your lordship expedite the second appeal. Most of them are senior citizens.
Move an early hearing. If they
Much
don't.
of it.
I'm seeking a passover. I'm appearing for respondent number 1. Mr. Tushar Mehta is one is raised in court number 1. I'm so.
I appear for the
11.
On the miscellaneous day, lordships, because it will take some time with regard to the consideration of the report, etc.
Oh, you say because of the CB, we'll have to have it only on these days.
Lordship may have it in October.
Lordships, this matter will take about at least half an hour, 45 minutes, and all high courts are also to respond.
Thanks. Yeah, just go to black. My lord, may I just make a small.
Some day when your lordships has sufficient time to hear it, because your lordships have some suggestions I want to place before your lordships, and this is not adversarial at all.
Yes, my lord, I am for the Supreme Court Legal Services Committee. My lord, we filed the affidavit, and my lord, I joined the request with the. In my case, it can be any day that's convenient to your lordship. But my lord, in the interim, the Legal Services Committee wanted some directions from your lordships, and I've just copied this. Give to me. Well, I'll read it for you. There are some bottlenecks we identified while we were preparing the affidavit, and this is something that the committee is regularly finding. They are trying to find mechanisms to address it. Now, two loopholes that they have identified are, where the matters are transmitted from the High Court to this court for legal aid, record transfer takes a very long time. So, my lord, there is some prayer that we have made. It can be done in the interim. My lord, the filing can be hastened. And my lord, one is that if the High Court Legal Services Committee, whenever a request is made by the Supreme Court Committee to them asking for record, now everything is electronically transferred, so they don't need to take so much time. We are saying within 7 days they can scan and transfer it to us. Now it will facilitate early filing. But the second request is whenever they forward a request to the committee here for any filing anything, it should come with the record. Many times just a letter is given to us, there is no record, and it takes sufficient quite a lot of time for us to access those records. So these two for the High Court Legal Services Committee. And now with respect to the jail, my lord, the biggest delay that one is finding is the custody certificates are coming in a very incomplete manner. It doesn't give full details about how many days the person was in custody. Now, without the registration in Supreme Court, the Supreme Court registry is extremely particular about the custody details. And if these things can be done, that is the direction that the committee is asking from your lordship.
So, but second prayer, jail authority, can you just elaborate?
Yes, my lord. The jail authority has to
be requested during the course of the day.
Yes,
elaborate.
Yes.
A little more.
Yes.
And then we'll pass it to
yes,
the
we'll do it before 4 o'clock. I'll give it to the court master and also give it to.
You may do one thing.
Yes.
Both of you sit down. Before,
What I wanted to just apprise you.
Just give us a note.
We do that, Your Lordship.
During the course of the day, and then we'll make that part of the order.
Very well. But only thing that I wanted to apprise Your Lordships is, which may not be aware of, that now there is an SOP for transmission of digital wakalatnamas, digital custody certificates, etc. So they have to just log into that portal and ask for that.
Very well. So all that you say,
yes, then it's coming.
They'll have mechanisms already there. They'll have to adhere to it.
Yes, within 7 days. Even then, it is coming late. Is what my instructions are.
We'll make that part of there. Both of you sit down, for that matter, all of you.
In fact, Lordship, for transmission of record.
Just prepare a note.
Yes, we'll do that.
That's what we are saying.
I will.
By the end of the day.
We'll do that.
Be part of the
yes.
Very good.
Your Lordship,
and for regular, for other issues, we keep it some other day.
Whenever Your Lordship is coming.
Then on a convenient day.
We will do that. We'll do that.
For High Court, we have no difficulty. But
there's a reason why we are not giving a date. We'll, in a day's time, when the orders are uploaded,
Very
it will be.
Very good.
Obliged.
Very.
Yes, please.
So immediately there are two FIRs. There is a dispute between these two groups. And I bought a land of 10 acres in that place. There was a dispute between these two groups. Now on 7th of July is the FIR filed by the respondent against me. And my lords, on 10th of July, I filed FIR against them. Now, your lordship, that FIR which I have filed is under section 307, 323, 149, 148, and 147. Now, my lords, 323 is voluntary cause in previous court. And my lords, 149 is about unlawful assembly and common object. 148 provides 3-year my lords punishment, variable non-compounded. Whereas 147 is also non-compounded. Now, it's what the High Court has did after filing charge sheet, your lordships, against them. They caused the charge sheet, my lords. As far as their charge sheet is concerned, it has been quashed.
Yes.
Now, if the lordship come to the finding given by the High Court at para 7, my lords.
Yes.
Obligation order, your lord. Peruse the charge sheet. It is admitted fact that there is a decree of perpetual injunction in favor of the applicants passed by the trial court and confirmed by the district court in appeal. The injury certificate show that all the injuries are simple in nature. Therefore, it cannot be inferred that any cognizable offence is committed by the applicants. There is a delay caused for lodging the report. Counter case is admittedly pending in the session court. Considering the delay caused for lodging the report, nature of injuries,
So may kindly appreciate.
How do you
First is yes, Lord. Answer, Lord.
How do you support this order?
Because Lords may kindly appreciate. Non-cognizable case was registered by the brother of the petitioner on the very same day on 4 July 2000.
Para 7.
Yes, Lord. Para 7. It is in respect of Lord the two FIRs came to be registered at the.
How do you support this order?
Lord, this order is considered the NC, which is non-cognizable case, which was registered under 323. That investigation without taking any magistrate permission. Lord, 307 is concerned. It is dropped by the police officer while filing the final report. Then, Lords may kindly appreciate. Only Lord, the Lords may bear with me only for a moment.
Trial, sir.
No, Lords may kindly appreciate. This injury, Lords may kindly appreciate. This is a second FIR, which is Lord a question before the Honorable High Court. This is not a first FIR. First information report was lodged, which was cognizable, non-cognizable. That was the registered under 323. And what is the charges which is at the final report, that 323, it is already in the non-cognizable case. 4th July 2020 itself, on the very same day. We lodged the complaint on 7 July 2020.
It is not a dispute that parties to the list had filed counter FIRs against each other. FIR number dated 4/7/2020, 7/7/2020 was got registered by Respondent Shivaji. You are Shivaji, na?
Yes.
Shivaji. Whereas FIR number 143 dated 10/7/2020 was got registered by the instant petitioner Bhima.
Yes, ma'am.
In a petition preferred by the respondent, Shivaji, the court below, the High Court has quashed the FIR.
Charge sheet.
Charge sheet, preferred charge sheet in relation to FIR number 143 filed by you. The petition stands allowed by assigning the following reasons. Para 7 of the 8th step. Here the considered view that the reasons assigned, so to say the least, are absolutely cryptic, and in fact the court has exceeded its jurisdiction in conducting a trial, in almost conducting a mini trial. So, whether a cognizable offence was made out or not is something for the court to see during trial. Particularly when in the FIR, it was alleged that in the charge sheet, particularly when in the charge sheet it was alleged that the respondent herein had committed an offence punishable under section 324, 147, 148, 149 and 504C.
I'm ready. But the facts again, she told me,
next.
I'm ready.
Lords, I appear for the state. The Lordships had indicated on the last occasion, Lords. But the High Court orders are well-reasoned order, Lords. The High Court could not have done anything else but prescribe the minimum punishment in case of his admission.
We'll have to acquit him now.
Lords, he has pleaded guilty.
Minimum
minimum is 3 months. 3 months, Lord. It can be reduced to 3 months. It is 6 months, but it can be reduced to 3 months under section 16.
Then probation.
DO will apply. Probation of
Offenders Act or
probation will should apply.
No.
We'll have to check.
You have to check in good international matters. Probably that may not.
I'll check. You'll also pass it over and check.
This will pass it.
We'll pass it.
Lunch के बाद ले.
Please, Lord. The matter is
before mediation was a
My lord, I was appointed amicus in this matter. They are still being there for the
Mediation. Mediation is in progress.
it is always stating, Lord,
It is in progress, Lord. Report be called for.
Very good.
My lord, the report may be shared with me because the interim report wasn't shared with me.
No, the final report.
Final report may be shared.
Final report we shall also be spread to learn.
Great relationships. But in this case, I'm a 74-year-old man. Lord, I was running a farm. 28/10/2013, Lord, page 27, your lordships will find. I am, Lord, resigned from, Lord, as a director of this company. Lord, one document is very material. May I request your lordships to kindly turn to it. 29, page 29, your lordships will find the request for loan. Your lordships could kindly turn to page 29.
What do you say, Mr. Sanjay? He is very clear. He says the agreement to sell is of 1st of October 2013. The stamp paper is of 24th of October 2013. And he had resigned on 28th of October 13 and new directors had already been.
But even thereafter, he had operated the bank account of the company, Lord. And that is because of that reason, Lord.
Where do you show that?
That's an
Charge sheet, Lord. I will come to the charge sheet, my Lord, annexure, my Lord. If your lordship will see the charge sheet.
Yes.
112 page, my Lord.
112.
Lordship.
You please just read that line that after his resignation, he had operated the bank of.
Lordships. Now, my Lord, at page 112, if your lordship will see.
Yes.
The paragraph, my Lord, first paragraph ends thereafter. In pursuant to a forced conspiracy, you accused Chandra Prakash Gupta as the then director of co-accused MCR FMPL remitted a sum of 35 lakh.
1 minute.
I'm sorry, page 112.
Yes.
Your lordship. 112 documented. We will just check up from the physical copy, my lord. I presume it is there. Lord, it starts, Lord, in pursuant to a forced conspiracy. Well, it's in physical copy, it's 111.
No, it is here.
Lordship,
111.
In pursuant
112 also. Yes. In pursuant to a forced conspiracy, you accused Chandra Prakash Gupta as the then director of your co-accused MCR FMPL remitted the sum of 35.50 lakhs in 3 tranches of rupees 27 lakhs, 8.25 lakhs and 2.25 lakhs from the aforesaid CC limit to your account, your wife's account and your son's account on 23/11/2023.
Thank you very much. Thank you.
Lord, lordships will kindly see.
Thank
this
you,
is
sir.
almost their own investigation.
Thank you.
Not this ground cannot operate. Not that's I challenged in the High Court.
It's a question of trial now.
But trial was stayed, my lord. That may be renewed.
My friend's charge sheet, the CBI's charge sheet is otherwise. Please see my role and page 9.
We are only reading the charge sheet.
Lord, that's a fact which is false. That is.
But if it is a false, are we to examine it?
Lord, your lordship have put them to notice. In their reply,
Gentlemen, why did we put them to notice? Because we put 2 queries to him. And he says, sir, please, after that you have printed the account.
Lord, I could not have. That's why I said.
That is the offense. You could not have, but you had.
I haven't. Page 29, the account.
You haven't. It is to be proved in course of trial. Whether you have or
not 28/10/2013.
It's not a case of 482.
Not just one fact, if your lordship is there. My lord was with me when my lord issued.
We were with you till the time he brought this to us.
That's the reason why, my lord.
Yeah.
What I had argued, may I just refresh your lordship's memory?
Nobody had argued, therefore we had made a report and we put straight away 2 questions to him.
Just one submission. Your lordship should please test me on that. 28/10/2013 is the request. The bank account is not opened in the name of the new directors. I am not a part, I am neither a signatory nor am I not part of that bank account. Lord, I possibly could not have withdrawn money after 28/10/2013.
Thank you, sir. Thank you.
I'm grateful.
Lordship, just observe that trial will continue. Otherwise, your trial has been stayed.
Intermediated with the dismissal of the SLP intermediate.
Lordship, if your lordship observe that, you will expeditiously go. Otherwise,
trial is expedient.
Great.
Lordship, I'm seeking 2 weeks time to resign. My learned friend just filed counter recently.
Rejoinder?
I'm not handling anything for a joinder, but which is keeping kind of.
I want to file.
The judgments are clear, my lord.
There may be so many things for a lawyer and a rejoinder.
Please, your lordship.
Yes, please.
Lordship, this is a FIR arising out of matrimonial disputes.
Correct. So,
and in account, I have filed complaints.
Any possibility of settlement?
My lord, I am for the I am ready, your lordship. I have engaged in the morning itself.
Any possibility of settlement?
Your lordship, I am ready, your lord. Your lordship will say, please.
Then we'll refer to mediation.
Yes, yes.
Mediation.
Grateful.
Pass over.
My lords, in 38, my lords, I appear on behalf of respondent, my lords. I seek some time to file my reply in this, my lords. I seek some time to file my reply, my lords. With just 2 weeks, my lords, and we will file our reply, my lords.
I am appearing for respondent for 4 months. I have filed my call.
Reply 2 weeks, rejoinder 1 week.
Great, lordship, great.
May I speak for password minutes?
Password.
Lordship, have it some other
On
day.
behalf of respondent 2 at India, respondent 3, 4 and 5. As directed by Lordship, Lord, I have filed the points of arguments also relating to Lord Hindu customary law, Lord prevailing Lord in the utable theory. I'm seeking for a password. I'm seeking.
No, other respondent is seeking password. No, we are not the petitioner. Password means I will be in difficulty. No? That's why.
Will you argue?
Then we start. He is seeking password.
You are seeking password.
R2. I'm for R2. I'm seeking a password.
11 senior is here.
R3 and 4.
I prefer R3, 3, 4 and 5. 3, 4 and 5. The second defendant in the suit. Also put a question to me relating to existence of the Hindu succession.
Difficulty in password?
No, I am not. I am not this after.
No, password. Why are you in difficulty? My lord is asking.
I have to go to Chennai. We have to attend a function.
You have to go to Chennai?
Yes.
We take his flight.
Some
other day.
Some day.
Next week, we'll have any day.
Request for some other day.
The request for a fixed date. Learned Senior comes from Chennai.
But
no, he comes from Chennai. Any fixed date.
Chennai, but any date.
Whatever date suits you, you give us that. Simple.
What's it?
My lords, the service is complete upon all the respondents. We seek time to file proof of dusty, my lord.
The tracking report service is there.
Yes, my lord.
You are the claimant, huh?
Yes, my lord.
And the insurer has to pay liability on the insurer?
Yes, my lord. Both the respondent has been served, my lord.
As per the office report, respondent stands served, no appearance.
Missing?
Yes, come forward. He is appointed as a Micus to assist the court. Copy these. List on potato. No figure.
Item 41.
My lords, in this matter, the respondent number 2 and 4, the service is incomplete upon that. Kindly grant us some time to take fresh steps.
Yes.
So, we seek some time to take fresh steps, my lord, for respondent number 2 and 4.
Per office report, respondent, as per office report, respondents, same except no 2 and 4, stand served, no appearance. You are not appearing. Who are you appearing for?
In the previous matter.
No, this matter. That matter is over. We want to mind. Copy will be.
He is asking.
2 and 4.
No.
How many minutes?
Yeah, that's it.
Name was counsel in the court. Your counsel? Registered counsel? Come. You see, even backbenchers get opportunity. What's her name?
Lordship, Vedushya Park.
You are working with whom?
I'm working with Ms. Rekha Palli.
Where have you graduated from?
Narsi Monji, Bombay.
Bombay. You're from Delhi or from?
I'm from Varanasi.
So we'll appoint you as a Michaels?
Yes, Your Lordship.
Appointed Michaels, copy dena. Steps of service of 2 to 4. Now, is made clear. Shall continue to assist the court even if the respondents are requested by then 2 to 4 steps, Rusty. You'll get a copy, just give your details, the name, email ID, and just interview. And you ask Ms. Palli, she said she guided you.
My lord, on this matter, only respondent number 2 is remaining. The service is incomplete. We just seek 2 weeks time to file service.
As per office report, respondent number 2 should not be served. Now, number 1 is served. Huh?
Yes, my lord. Only 2 is remaining.
Yes, who's the next junior most counsel? Anyone? So many of them. Okay. Who's the junior most amongst you? Give the name. We don't know enrollment wise. Whosoever raise hand, give us the date of enrollment and then yes. And then steps of service of number 2, we taken the steam addition. 1 week the steam addition. We'll just be back in 5 minutes. Yes, please.
For the petitioner, the parties have filed the petition together. My lord may have that ID 211627. There are certain cases pending, details of which we have given at paragraph 3 of page 3 of that.
We have seen that.
And Lord, page 5 is the payment terms, and page 7 is the time to vacate the property. And Lord, my lord may allow the application not in between not the first semester fee which he has paid, he has reimbursed. And he has reimbursed. Lord,
the parties have.
so my client is also there logged in. My lord, he is online.
Yes,
he is online, and I believe the wife is here.
Parties have filed instant application, placing on record the terms of settlement. The usual order. Money and the payments ends.
The terms is that by December 2025, 2 crore will be paid, and the rest 1 crore will be paid in.
Parties abide to adhere to the terms of the
yes, that
parties undertake to abide.
Yes.
To the terms. They are present.
Yes.
In the Mr. Das is joined digitally.
My client is there.
1 minute. Was
Yes,
identified by what's her good name?
Srijit
Chakravarti. And Miss Kanya Das, who's physically present in court, is identified by
Kumar D.
Parties, student council have been made aware of the consequences of the breach of the undertaking. So the payment as stipulated in clause 3 of the agreement, the terms of payment shall be adhered to. And insofar as the other terms stipulated in para 3.2 and 3.3 with regard to the vocation of the property, and more so with regard to the vocation of the property shall be adhered to by the parties. Then marriage is dissolved. Decree withdrawn.
Well, here acrimonies between them has been resolved today with your lordship places. We are extremely grateful to us.
Thank you very much.
Grateful.
The council and also the party. We have been able to see what weighs in our mind is that the burden of the judiciary is listened. Thank you.
SLP is complete, but no one has filed their counter. No counter is open.
Yes, sir.
Service is complete, but no one has filed any counter.
Because this is a matter of competing claims between the deceased applicant before the tribunal and the respondent number 2.
Correct.
Now, an order was, the matter is filed in 1996.
Yes.
It dies in 2002. An order is passed in 2009 in favor of a dead person. That order is challenged by the respondent number 2. These are competing claims. Both of them were working in a college, in a private aided institution.
Yes.
And the grant in aid was the subject matter of dispute, which was granted by the state. Now, whether the deceased, the husband of the deceased, the husband who's dead now, whether he is eligible to get it or the respondent number 2.
So therefore, what is the impugned order? Why have we issued notice?
Lord, the impugned order is that since an order is passed in favor of a dead person when he was dead in 2002, the order is a nullity. And that's the judgment of your lordship. I have the judgment of your lordship once I can pass it on, that against a dead person in favor, and whenever it is sought to be implemented, the person concerned can.
Yes.
And these are competing claims.
What do you say to the para 6, sir?
No. Let me explain. He is appearing on behalf of the state only. He has hardly any role with regard to.
No, but para 6, how do you?
Para 6, man. Having heard learned counsel for the appearing parties, after going through the material approval, it is found that applicant number 1/6 died in 07/2002 during the pendency of the matter before this court in OJC number so and so, which was subsequently transferred and registered GI case now in the position. Court is not inclined to substitute. My lord, please come to page. My lord, the answer is straight. My lord, please come to page.
Who are you?
Page 29.
Who are you?
Let me explain. There are three persons. I'm the junior clerk in the college. There are 3 persons appointed in a particular.
1 minute. Who are you? Who died?
I died. My husband died.
So the legal order to be given benefit.
That's what I'm saying.
That's the point.
Please come to page 29. Please come to page 29. My lord, the learned tribunal. Madam, para 15. Para 15 at page 29, madam. Para 15. The learned counsel for OP number 5 has filed the death certificate of applicant number 1. It goes to show that he died on 7/4/2002. No doubt he has not been substituted by any of his heirs, but then his family members have to get the benefit which the applicant would have got had he alive till 7/4/2002. My eligibility was, let me explain. There are 3 persons appointed in a particular college. The particular college got approval of granting aid in the year 1996. All the 3 names were sent for approval. Me and another person were selected. The 3rd person, who is appellant before the High Court, was the learned tribunal, after meticulously going through the entire document on record and their eligibility of all the 3 persons, finally decided me, my husband, and another person were supposed to be 2 persons were supposed to get the benefit of the granting aid. The 3rd person who challenged this in FAO by filing FAO in the High Court.
Mr. Mishra.
Yes, sir.
Whether this principle of a decree in favor of a dead person,
yes, sir,
which applies to civil proceedings,
yes, sir,
would also apply to proceedings in service law.
I'll just tell you. The first application was filed by him because the government
that was allowed by the.
I'll just tell you, Lord. So because of
means that some original application filed by the deceased husband of the petitioner, that was allowed by the tribunal.
No, my lord. There was no application for bringing on record the legal heirs.
Forget about legal heirs. Yes. The respondent number 6, the husband of respondent number 6 or respondent number 6 moved an application.
Yes.
Before the tribunal.
Yes.
That was allowed.
No, my lord. There was no application moved. It was only informed to the tribunal, if your lordship will look at that order, that the applicant had died in 2002. And that is how the applicant passes an order that the benefit should be granted to him.
What order in his favor was passed by the tribunal?
Yes, my lord. Your lordship will look at page 29. Now the order granting aid in favor of the respondent number 2 was quashed by the tribunal.
The respondent number 2 is?
The respondent number 2 is the petitioner before the High Court. Now there are competing claims. Now your lordship will appreciate.
No, there may be competing claims, but as on the date of death of the husband of the petitioner,
yes,
there was some right or entitlement.
There was no right which accrued. There was an original application pending before the tribunal claiming that I am entitled to it.
What happened to that original application?
That original application, the order is at page 29, the final order.
Yes.
And that order is
That was allowed.
That passed in 2009.
That was allowed.
That was allowed.
Why are you saying repeatedly that nothing was allowed when it was allowed in his favor?
In 2009.
Whatever.
Yes.
In 2009.
Yes.
And therefore you are saying that it was passed in favor of a dead person.
Yes.
And therefore legal heirs cannot be substituted.
I'll just go to the next point.
Only a question of substitution of legal heirs.
I'll just go to the next point. That this order was challenged by the person in whose favor granting aid was before the High Court.
Yes, we understand.
Now these are the competing claims. Now the respondent number 2
So why are you emphasizing so much?
Will be prejudiced.
Why are you emphasizing so much about this competing claim?
Yes, please.
Competing claim is not decided by the High Court.
No,
High Court has only decided the substitution application.
The High Court goes on a technical.
Substitution application only.
Yes, please.
You will allow it and send it back to the High Court to decide the competing claim, as you are repeatedly indicating.
My lord, my only claim is that
I leave it to your lordship.
Only up to 2002 I am entitled. My lord, I am saying.
Allowed in today's date.
Very well. Lord, of course, I have a judgment if I can just pass it on.
Yes, please.
Your lordship.
And we also both of us to file written note of submission for lordship. I'm ready.
You just pass on the judgment. You just give the copies to us. Don't file written note. A copy of that judgment which you rely, just pass it.
Today itself. The footnotes and paragraph 22 is important.
Just 1 minute. Paragraph
22 and the footnotes. Any decision in favor of or against a dead person renders
CPC proceeding. That CPC principle.
Yes,
that is why I asked you whether that CPC principle of decree in favor of a dead person applies to service law proceeding also.
Lord, my humble submission will be
not submission.
When
enlighten us.
That's what I'm saying. Yes. When there are competing claims, because again I'm repeating.
Again, competing claim is not decided by the High Court.
High Court has not decided.
It has only disallowed the substitution application.
The tribunal decides in favor of a dead person. So therefore, my humble submission will be this is applicable to.
So suppose there are two competing claims between two employees. Yes. One employee dies.
Yes, my lord.
The other employee will automatically get the benefit.
No, my lord. The legal heirs can substitute themselves there, saying that the entitlement is of the deceased person. Therefore, we are continuing with the proceeding.
We have understood. Yes, next.
Very grateful.
But I appear as amicus on behalf of the petitioner.
I am appearing for the respondent. Malats, this has a web of litigations. Malats, I could examine it yesterday. Malats, if my lords are kind enough to give me some time so that I can put a short note, my lords, along with some documents which they haven't filed. The petitioner hasn't filed, especially the misconduct proceedings, where, my lords, after evidence, it was decided by the court that there is misconduct on her part. My lords, I would want to bring that on record. It's in Marathi, and that is why sometimes.
We had requested you earlier also.
Yes.
Let me allow oral please.
He wants time.
I won't come in the way. Let them bring whatever they, because lordships have given them last opportunity on 18 July. But be that as it may, let them file whatever they want to file. The record should come before your lordship.
On 18th of July, we had said no
yes,
problem.
I went through that, my lords.
Otherwise, I have a note of arguments, but not basis what they will now file. I'll revise the note and file.
With me so that
No, basis what they file, I'll revise the note and share it.
That is adjourned by 1 week. 1 week, ma'am. She's poor.
I understand that.
1 week. Rejoinder, if any, 1 week.
Grateful. Grateful. So deeply obliged.
Obliged. Grateful.
I request the council to fund.
Lordship, very deeply.
It is a lordship.
But I'm in some difficulty in the week starting 22nd September. Not if it's before that, there's no 22nd after. Very well. I'm grateful.
My lords, I was appointed as an amicus on the last occasion in this morning. I tried getting in touch with the respondents. I was not able to do so. However, I was able to get in touch with their local council. As per him, the respondents are very poor. Respondent number 1 is also suffering from some health ailments, and is therefore they do not have any means of coming to the Supreme Court.
Did you appraise them of their statutory right of legal aid counsel?
Yes, ma'am.
Well, the limited issue was 3,700 days of delay in the restoration of the appeal, which was dismissed for non-prosecution. The High Court excluded 726 days of the interest, and 3,700 days which was taken.
How much of difference would it be in terms of money?
10 years, 10 years of interest.
You're only asking how much.
Of
in terms of money, how much would that be?
I'll
Around 3 lakhs.
No, I'll be more than.
We just go out. If it's only 3 lakhs, they are poor people.
No,
we understand that the delay in approaching the court is something they have to explain. But if the learner of Midas has already taken, stupid action. Just see what is the delay. What is the amount?
I'll just calculate it.
Just calculate.
Yes.
If it's just 3 lakhs, then we'll put a quietest to it.
Very well. I'll just calculate.
Just pass it.
Just calculate.
Item 47, your lordships were pleased to issue notice to explore the possibility of settlement.
Yes, who are there? Who is there? Yes, Mr. Counsel.
Lords, I am for the respondent in this matter of Lords.
Any possibility of settlement?
Lordship, the respondent always intend to live with the petitioner of Lords.
Should we refer to mediation or no?
Lordship, if there is possibility, yes, Lordship, I am having the direction, I am having the instruction that
may it be sent to Madras High Court Mediation Center, your Lordship. It will be convenient for both the parties.
Madras High Court Mediation.
Lordship and Lordship, I am.
Yes, mediation center attached with the Court of Judicial Checker.
Lordship, I am also seeking the permission to file my counter affidavit within 4 weeks.
No, first mediation.
Okay, Lords.
Mediation called.
48.
Yes, please. There.
Some respondents moved a letter.
For counter affidavit.
Filing our counter.
Why? It has to be allowed only anyhow.
It's last opportunity.
1 week is under 1 week list on, no further.
49.
49, Lord. This matter raises substantial question of law, Lord, that whether the government employee, Lord, if there is any dispute on the part of government employee in reference of the fixation of pay, whether he has any right not to vacate the government premises.
So you have a right.
No, Lord. The problem in this matter is, Lord, in 2003.
Yes, who's the respondent?
Lord, I answer this. Lord, admittedly, my retired dues are.
No, 1 minute.
Yes.
See, dues were undisputedly, irrefutably, they owed money to you.
Yes.
And that was towards your retirement benefits.
Paid after 3 years.
Whatever it is.
Yes.
Do you have a right to retain government accommodation?
No, why did the High Court interfere? It's because of your Lordship's 2001 judgment, which is quoted by the learned single judge, that the fact that a government employee has not vacated the government accommodation is not a ground to withhold retirement benefits. So the High Court has taken note of the fact, because the government was writing letters to me, first you vacate, only then I will release your retirement benefits.
Where is that letter?
Yes.
Reply, where do you say?
Lord, please see the letter.
Reply, where is that letter?
Yes, page 37 of my counter affidavit. Page 37 of my counter affidavit.
No.
Yes.
In your reply.
Yeah. Yes, sir.
Where is that communication of the government that please, only if you will vacate, we pay the amount?
My Lord, the reply filed by the state before the High Court has a para 3, page 38. Page 38, reply of the state I am reading. Page 38 of my counter. Paragraph 3. May I read you? It refers to that very letter. What your lordships are referring to.
Where is that letter?
Not the letter is not on record, but it quotes the letter saying that you vacate, then I will pay. Please see page 38 for a moment.
We have seen page 38.
Yes, may I read now? That the petitioner has been directed to vacate government residential house allotted number so and so. dated so that the department may issue a certificate of vacancy of the government residential house to the petitioner, and the petitioner can get pension. This is the stand of the state, and this is directly. Now, please see your Lordship's 2001 judgment, which is quoted by the learned single judge. Please see page 24. Page 24, single judge. Paragraph 6, Lord. Towards the last part, page 24. This is 2001, 6 SCC, page 591. Now, please see the quoted part, my lord. My lords have it, my lord. Pension and gratuity are no longer matters of any bounty to be distributed by the government, but are valuable rights acquired and property in their hands, and any delay in settlement and disbursement whereof should be viewed seriously and dealt with severely by imposing penalty in the form of payment of interest. Withholding of quarters allotted while in service, even after retirement, without vacating the same, is not a valid ground to withhold the disbursement of terminal benefits. This is exactly what they have done for 3 years. 2013, I retired.
Why did you not vacate is what we are asking.
Lord, so therefore, my lord, my respectful submission is, because they are also pari delicto, my lord, they have also not acted in accordance with law, and they for 3 years.
Page 6, page 38, para 6.
Not the problem.
We did not pay because he was not vacating.
Not the problem.
It was both the way. He was saying, I will not vacate unless you pay.
Yes.
And you were saying,
you please pay
that we will not pay. But you cannot behave like that.
No, the problem.
You are a state.
The problem
Your
on behalf of the
difficulty is
state
that
is this.
you are a state.
Lord, the problem on behalf of the state is this, Lord.
Where is the rule?
If there is
You see, when state insists for some action or some action on the part of the employee, it must be supported by rules.
Yes.
Where is the rule? That if he doesn't vacate, you will withhold pension. For withholding pension, there has to be rules.
Not this, Lord.
If it is not permissible rules, you have to pay.
Lord, may I explain? In 2006, Lord, he was promoted on the next level. At the time when he was promoted,
not concerned with that. It is only about that part.
Lord, there was some problem in fixation of the pay scale. So he furnished an undertaking that I will.
One minute. Yes. What we'll do is, so that the officers of the state are very clear in future, we are going to dismiss this petition, but we'll let you wait. CAB कर लीजिए, लिखिएगा. So this is not part of the order. Even though we dismiss the petition, but however we will lay down the law that pension cannot be withheld only for the reason that the employee is failed to vacate the premises from the counter affidavit filed by the state of the High Court. More specifically, para 3 and 6, it is evidently clear that the pension was withheld only for such.
Lord, that was not the problem. That's why I am trying to explain, Lord. There was time. It took time, Lord, because his pay was not fixed, Lord. So it took some time for us, Lord, to calculate the pension, and for that time it did not vacate the premises.
Thank you. You said so on oath in the High Court.
The difficulty. He retired in 2000.
आपने वो High Court में नहीं बोला.
Lordship. Obliged.
My lord, as per office report, the service is not complete, my lord. It is in
per office report. Then why did we issue notice?
My lord, your lordship has issued notice to the extent that
to explore this
only for settlement.
Notice was confined only for exploring the possibility of settlement. As per office report, the respondent could not be served. Let fresh steps. Dasti. You take Dasti, otherwise we'll dismiss it. Dasti. in addition.
Can service may be through the local trial court, my lord, or police station?
Take the stay.
Please, Lordship. Lordship, I appear for the petitioner in item 51, Lordship.
Yes.
72 is tagged with it. Lordship, please to issue notice. Lordship, respondent number 1 and 2 have filed their counter affidavit, which we received on Saturday afternoon, Lordship. 3 was on caveat. The rest, there's no vakalatnama on behalf of the rest 5 respondents.
And looks in the second connected matter, we looks all services awaited. This subsequent one, yes.
We'll pass this over, pass it over. Wait.
I'm 72 for
No, we'll take it up with 72.
No, no,
Lordship, contempt is not on record.
I have one difficulty.
Lordship, contempt is not.
Just 1 second, sir.
Bypass surgery. I want 8 week time, my lordship.
Just 1 second.
Our balance means bypass surgery.
Looks what has happened, looks. Your lordship looks issued notice in the first matter. Thereafter, looks in another matter also and tagged it. Now, looks by way of supplementary 71 is tagged with 51 itself. Right. So in the second matter, looks services are awaited on all the respondents. Looks only I have, since I was on caveat, looks I accepted notice. So looks lordship may grant some time. Looks all will appear, file their pleadings. Thereafter, lordship will fix it for hearing.
At least my lordship, my senior.
Just 1 second.
Who's senior?
Bala Subramanian.
Not understanding it.
No. Seniors
He's also saying so. Same thing he's saying, but in a different language.
No, it's all needs to be heard. It's all.
The service are awaited.
Yes, plus. In the second matter, plus. Office report indicates that.
This ground you reserve for next adjournment.
In my matter, respondent number 4 to 8, service is complete, but nobody is entered appearance.
Chosen not to enter.
Lordship, please.
First case में करेगा, even though service is complete upon
4 to 8.
4 to 8, none has chosen to enter appearance, proceed expire. Then second में करेगा, as per office report, respondents number 1, 3 and 5 to 6 is awaited. Let fresh steps for service. Fresh steps for service.
One week time.
That's the
Lordship, in the first matter, R1 and R2 they filed their counter on Saturday. Lordship, the permit to file rejoinder.
That's the trial court matter.
That's the in addition.
Obliged. Lordship, the parties are common in both the matters. So I think that can be worked out. I don't know if I can. Because parties are common. It's arising out of the same impugned order, Lordship.
Are you there for the respondents?
I'm not getting any counter anything.
Please simply.
Lordship, I adjourn it, it will be done.
Obliged. Obliged.
I'm obliged.
For the petition.
For mediation?
Yes, my lord. For mediation, it will be referred before Kerala High Court Mediation Center.
Kerala High Court Mediation Center.
Date will be given for mediation. Mediation, a date will be given.
Some date will be
Grateful.
Somebody is entered
No,
appear, sir.
we just received the
Report says service is complete.
We just received instructions to appear in the matter. I request for some time to file wakalat.
power attorney and response be filed within 2 weeks to join the 1 week, no further off.
Great.
Lordship said already granted a status quo.
Status quo until to continue.
Deeply obliged.
Lordship, I am for the petitioner in this matter. As per the office report, the respondents have been served on 11th August. However, there has been no appearance and the reply has not also been filed.
Lords, we appear for the respondent in the Union of India and Ministry of Information Technology.
What about the other parties? Na?
Lord, other is CDAC, my lord.
You will appear for all of them then. CTAC, you obtain instructions.
It's part of the government.
It is appearing on behalf of all the respondents. Then put it differently. Put it differently. Appears on behalf of respondent number 1. We find that respondent number 2 is part of
2 to 6.
2 to 6 are part of respondent number 1 only. As such, we request 11 days to enter appearance. Then the reply we filed
4 weeks.
No, 2 weeks.
If 2 weeks will be less, not
2 weeks, 1 week.
At least 3 weeks.
2 weeks, 1 week. At least 1 week.
During the petitioner matters. For your lordships today seeking enhancement of compensation grant.
Yeah.
Well, as according to me, all the heads have been granted. They asked for 8,000 rupees, is the income which has been considered, which has been granted, though the notional minimum wages would have been less at that point of time. Future prospect of 40% has been granted, so there is no head under which they can be granted any more compensation.
My lords, may come to page number D of the SLP. We prepared a table which compares the compensation that we had claimed and what had been granted.
Pain and suffering has to be enhanced.
Malas, the fact of the matter is pain and suffering has been granted, but the
18-year-old.
they have not been able to prove anything, Malas. They have not even proved the income before the trial court.
Minimum wages are even there to be taken.
Minimum wages was there more than less than this in 2014. Sir, 1 minute, please. In 2014, the minimum wages were
Pain and
less.
suffering has to be enhanced.
Malas, that has already. That is what they claim. Malas may have a look at
the pain and suffering.
Malas may.
Disability.
He has no future.
Malas, he is able to work.
My lords, may come to the
Malas, what they claim in the claim petition.
Loss of marriage prospect, nothing has been given.
Nothing has been granted.
Malas, that's one head, Malas.
Future medical charges, nothing has been granted. Loss of earning during treatment, nothing has been granted. And also during of loss of expectation, life hardship, nothing has been granted. And these are all recognized heads which this court has been granting for in multiple matters.
To increase as far as future medical expenses concerned, marriage prospects is concerned, pain and suffering is concerned, attendant charges is concerned.
Malas, can I say with all due respect, there is not even a moment that the attendant was employed. Malas may have the look at the judgment of this court in Rajkumar versus Ajay. Sir, let me complete with 1 minute. Malas may have a look at the judgment of Rajkumar versus Ajay Kumar, in which the heads of the pecuniary and non-pecuniary damages have been defined.
Charges will reduce. Whatever we have thought of.
Malas, the fact of the matter is in the appeal, they have not even stated that they have employed an attendant. And there is a judgment of 3-judge bench of this honorable court case which says instead of a multiplier, lump sum amount can be granted depending upon the start of the society from which
They are doing that.
I just say a couple of things.
Lump sum charge.
And the accident happened. She was 18 years old.
deeply obliged.
For charter.
Lordship, service is complete. Lord, our counter is under preparation. We take some time to file our counter. Kindly grant us 2 weeks' time. We'll file our counter. Although in the earlier order it was mentioned that the counter may be filed, but then it will not be filed. So I need 2 weeks' time.
No problem.
2 weeks, 1 week, no further opportunity.
Great.
This is already completed, record. Testing also not completed. They have taken testing and
As per office report,
yes, please.
Respondent stands served. Yes, okay. Yes, please.
Lord, this is not the factor case, my lord, the 42 years ago, my lord, and my lord, he died due to an accident. Lord, we made, my lord, the compensation, claiming compensation of, my lord, restricted, my lord, 50 lakhs. But that was negative, my lord, no compensation was granted and
It was dismissed because there was no evidence. But you kindly page 47, perhaps that's the evidence.
yes, there is, I think.
1 minute. Since there's going to be increase, we'll wait for some time. In the meantime, you can appoint someone like this. Yes, who's the unanimous counsel in the court? Lady, you come forward. What's your name? Please give a name.
Lords, my name is Eshna Jain.
You're working with?
I'm working with a law firm called Simmons and in Gurunagar Park.
You regularly come to the court?
My
The
lord,
law firms normally don't allow,
my lords, we
appoint you, Micus, would you be?
please, my lords.
We don't know whether your senior would allow you to come to court.
My lords, I will have a word with my senior in this regard. I don't think there will be an issue.
And if he says no, then
My lords, I don't think
it's
they.
appointed as a Micus to assist the court. Should the respondents file be represented through regular counsel, still continue to assist.
Grateful, my lords.
Because there is going to be some substantial increase.
Yes.
Because it has been dismissed concurrently. A PW2 is there.
Yes. Yes.
Grateful.
Just give your name, number, email ID, address, and this. Yes.
Also, letter of adjournment has been given.
Not in this.
There is no letter. In item 58. It was circulated on Friday.
I appear for respondent number 13. We were served with a notice saying that there is an adjournment letter in the matter minutes for 2 weeks, and the personal difficulty we AOR, it seems.
Also, as per the office report, service is not complete for some of the respondents.
For office?
They had to do dusty alerts as per the last order.
Just 1 minute. For office report, service could not be completed upon 7 and 8, 10 and 11, 10, 11, 12. Rest steps of service within 2 days, dusty. In complete and latest particulars be furnished within 1 week. Notice return in the dash.
And specific date minutes.
Some date will be there now.
Grateful minutes.
In the meanwhile, appearing parties may file their reply within 2 weeks.
We have 5 minutes, which is on record.
If not already filed, rejoinder within 1 week thereafter.
Grateful minutes.
In item 59, we have filed a spare copy on 21st July, but office report is service report is awaited as per the office report also. So we have received the dusty from the registry on 30 August.
As per office report, respondents could not be, service correspondence is incomplete. Then fresh notices, furnishing better particulars, journal dash.
Please, my lords. My lords, in item number 60, my lord, I have served through my investigator by appointing an investigator through the company. I want to place that report on record. Apart from that, my lords, I have also deposited the amount in compliance of the honorable court direction, my lords. Yes.
Item number 60, my lords, I appear for the respondent number 1. Lords, the authorized, after I received the vakalatnama of the director of the respondent number 1, my lords, he expired on 21st of August. So I had to call for another vakalatnama because his signature is there. I will file my vakalatnama as instructions to appear for respondent number 1. I file my vakalatnama and reply.
Please, if I may submit, my lords, with respect to the respond number 225, respond number 2 to respond number 5, we have also served dusty. I have received the report. I will file that the affidavit of the petitioner, my lords, with respect to the service of the other respondents.
As per Lord Counsel submits the respondents 2 to 5 stand served, right?
Please, I'll file that affidavit.
He shall file proof of service that it should be done within 1 week. Then Kalatnama on behalf of respondent number 1 be filed in 1 week. You are the owner?
Yes, ma'am.
You will have to answer.
Yes, please.
Counter affidavit will be within 1 week. By the appeal parties, the joint of 1 week. You are the main person actually.
Yes, ma'am. I am the.
This is the application. Because I am just seeking the temporary release for only 14 days.
Why?
Because there is a marriage of the daughter. In fact, it is adopted daughter without a real mother. So, Your Lordship, can you just see the application, page 8.
Page
8 of the IN. 8 of the IN. This is the Marriage card, I placed it on record without 3rd September, the marriage is there.
Marriage of?
Marriage of my brother's daughter.
There is no page 8.
Page 8 with annexer P. Annexer P.
Marriage of?
I'm so sorry.
Marriage of whom?
Marriage of my brother's daughter. Even I adopted the daughter. This accused is adopted the daughter. Real brother-daughter marriage. So kindly just permit me to at least 14 days temporary release. Otherwise, he's more than 8 years, 10 months. He was in custody. He is in jail.
Petitioner stands convicted for having committed an offence punishable under section 302 of C. The appeal is admitted.
Appeal is admitted.
The appeal already stands admitted. So, application, for the reasons signed therein, allowed. Petitioner is allowed on interim bail for a period of 15 days.
15 days.
15 days.
As your lordship, 14 days we have prayed it. Your lordship, I'm leaving to your lordship, at least he will attend the marriage.
Marriage is on 3rd September.
3rd September. That's it.
Day after.
Yes, day after. Because with this application was
1 week is sufficient.
At least
You will be released tomorrow, you will attend marriage day after. And then
after I'm leaving to your lordship.
Performing Kanyadan, whatever ritual.
There I want to meet also.
If at all sees your adoption.
It's a long time, I am in custody. At least I will.
Your lordship.
Why are you doing pro bono
Well,
to an NDPS accused?
Well, it's a very poor family. I personally met.
Nobody does pro bono for an NDPS accused.
I am making a submission.
We were also on that side.
Well, it's a very.
We were also on that side. And if your definition of pro bono is not less than 1 lakh, then we don't know.
I'm making a responsible statement that this is a pro bono.
No, business.
Sorry, dear. No.
Because the co-accused has already been granted.
Thank you. Antecedents. It is not that co-accused. Antecedents are also there.
Well, please have the FIR with me just 1 minute.
We'll have it, no problem.
Just
tell us what you want.
Yes.
See, co-accused has been granted bail, recovery is from you as also the.
Well, it's just the FIR for 1 minute.
How do you explain the antecedents?
Well, it's the antecedents. Well, my averment is that I've been framed wrongly. Just have the FIR
in relation to which offence?
Well, it's NDPS offence.
NDPS, same crime, same nature.
Well, it's just
Thank you. Thank you.
There's no independent.
Thank you.
Then my laws may permit me to withdraw them.
Okay, withdraw. तो उससे फीस बढ़ जाएगी?
Well, there's no fees, but it's
withdraw. Next case.
With liberty to approach the.
Millards, in this case, the only condition is local securities. Whereas I reside in Delhi, case is in Gurgaon.
So
my wife and my son is there. So I'm 73-year-old. Nobody local from Gurgaon is there. That is the only request.
No.
I may be allowed to furnish the security of my wife and my son.
No. Local surety too.
Millards, wife and son, Millards, actually he is 73-year-old. Millards. Nobody.
You are lucky you got the bail.
That is there, Millards. Millards, I am requesting only one condition. Amount may be same, Millards, but only
you are lucky you got the bail. We are telling.
From Delhi to Gurgaon.
Next case.
Please. By the same order, my husband has been granted bail.
Unfortunately, why the court did not grant to you?
Just no reasons are actually assigned for non-granting bail. They just considered. There are multiple transactions between the parties, and if you will see at page 28, there was a previous agreement. Previous agreement between the parties wherein I paid 6,05,000. And if Lordship will see at page 30, I returned them out of 1,83,000. I returned 1,16,000. Case is completely of civil nature, and all transactions, there are multiple transactions between the parties.
Notice. Yeah, interpret.
Great.
Item 66 is a fresh SLP.
Yes.
The learned family court rejected the respondent's divorce petition and rendered a finding that all the evidence that has been produced with respect to cruelty and desertion
they do not stand the ground, because the High Court doesn't disturb the.
So
Please elections. Well, it's the High Court grants stay methods in view of the orders passed in first round of litigation methods. Well, it's a consequential order is under challenge methods. Well, it's initial round methods went up till this honorable court methods. My difficulty is methods. Well, these orders, well, this honorable court has rendered that SLP instructors in view of this consequential order, which was well subsequently challenged, which was under challenge before
this report. The next date of hearing only, na?
Well, it's yes, your lordships are right, but
go there and tell the court.
My only requirement, well, your lordships may only clarify well, the orders that were passed in first round, well, because the SLP which has travelled up till this court, well, was rendered instructors in view of consequential order. That consequential order, well,
we are not clarifying anything. What is before us is not that previous history. What is before us is this order.
Well, please give me a minute. Well, you should see the writ court order, well, for a minute. Well, the writ court, well, relies upon.
Only come to page 2.
Well,
what is the order and the challenge before us?
Well, it's why I am here before your lordship is. Well, that order before this honorable, when the SLP in the first round travelled up to.
What we are saying is, sir, what is before us?
Is
this an application of a MA in that order?
Well, that MA was filed, your lordship, sir. Well, disputes that MA. Well, it's garlic matter. Garlic matter. Well, that MA was disputed. My difficulty is, this order is coming in my way. This writ for R1 is, empty formality. They'll refer to division bench judgment.
We don't know what they will do. We don't know what we will do.
Then I will be suffering. A lot of farmers, those who will suffer. They have been charging commission wrongly in the matter. It is not permissible.
Of an interim order, do not in the nature of interim, you know, in time.
The lordship may only clarify that order passed cannot be referred.
This is an ejectment against me.
Who are you?
This is an ejectment.
Who are you?
That's petitioner.
Oh, you are a petitioner. We know that. You are the landlord.
I'm the tenant village.
You are the litigant. Okay. You are the tenant or the landlord.
Yes, bullets. I'm the tenant village.
Correct.
Concurrently. The short point is the this ejectment petition was filed on the ground that there are two shops. And one of the shop he cannot use, and the other he wants to use where I am being based millets as a tenant millets. I'm a poor dweller.
Fees आ गई आपकी कि नहीं?
These millets.
Fees आ गई. ठीक है. अब हमें बताइए कितना टाइम लेंगे आप खाली करने?
Millets 2 years, please.
Oh.
Then whatever falls from this honorable court, I'll accept that.
You tell us, be reasonable.
Millets at least 1 year.
No, there's no question. This is not a halwai shop which is.
Millets, I understand, but he's a poor dealer. Millets, he has been staying there for so long. Millets, at least 9 months begin.
Okay, 9 months.
So great.
Undertaking.
So great. Well, I beg to appear for the petitioner.
Yes, sir.
Well, the impugned order is devoid of consideration, is devoid of jurisdiction. I take my lordship to page.
Who are you?
Well, I am the father. My lord, in a transfer petition filed by the father, my lord, an order is passed, gives the custody of the child whom she abandoned 3 years ago, in between an academic year. Kindly take.
We are issuing notice.
Yes, sir.
We are issuing notice. We'll give a short date.
Yes, sir.
We'll explore the possibility of settlement also. And today the custody is with you.
Yes, sir. A contempt has already been issued.
If your honor permits, I request to take notice in this matter, your honor.
Yes, ma'am, you're there.
Yes, your honor. Your honor, during 4.5-year-old.
We are only asking you today the child is with whom?
With the father, your honor.
Correct. So therefore, till the next date, let status quo be maintained as it is. You file a reply and come see whether there is any possibility of settlement. Is there any possibility of settlement?
The matter was referred before the High Court only for settlement, your honor. They are not ready for settlement, your honor.
Okay,
since the child was 4 years old, they have kept
Just 1 minute.
Yes, your honor.
We are trained mediators now. By virtue of our experience, we have become trained mediators. All of you, both of you remain present in court. Let the parties remain present in court on dash. Meanwhile, the state operations.
Any short date, your honor?
Short date will be, you tell us tomorrow?
Your honor, a week's time, your honor.
Okay, week's time. We'll reassemble at 2 o'clock.
Let the child be brought, your honor.
Thank you. Yes, please.
So that just hand over.
Availability tomorrow day after.
Problem is constitution bench.
No. Today was there is no CV.
So today is no CV. Luckily there is no CV either.
Because tomorrow now our bench constitution is also changed.
Oh, I see.
So we'll have to now find out time to finish this.
Because we then fix it on a day then what?
No, we can hear you today or what? No, two things are crossing our mind. Either we hear you today because we have leftover matters, finish that and then take it up. How much time would you take? We just wanted to
take a bit of time.
No problem. How much time this said?
Arguments are concluded. Now he took a little more time to add. Look, the Lordship was kind enough to hear all parties out for quite a long time.
At the time, each one of you exhaust your breath.
Now it depends on how long does it take.
Not stop.
If it doesn't open the case,
it's better give it in a day when we can be heard mothers at length instead of being pressured by this law. That's better.
CV is any tips.
What we can do, I'm suggesting it, that the CV, I will be arguing on Tuesday and Wednesday. And then you can fix it next week sometime. Others.
What?
Yes, next week we can get according to our program also.
What we'll do is next week we fix this matter on Monday.
Very
at 2 p.m.
Very good.
If this bench is sitting, then we can have it earlier also.
Fine.
If this bench is not sitting, then this bench would be.
That's fine.
Would that
Very good. Then give us the afternoon so that it can be okay.
We appreciate it.
There is also 24.
My notes. Lordship is supposed to be it on 8.
Monday.
And my lords, we're grateful for that chunk of time because there are some new points that have been raised that we will just address briefly.
Puff up our lungs and so that they are crushed.
You said at the time.
We try to puff them up.
He's trying to say we will exhaust ourselves outside partially. So
as not to exhaust my lords.
Yeah, I've just circulated this. Maybe your lordship should react to
list on Monday.
My lords. Mr. Gopal Subramaniam was also there. He is not there till the 10th minute. Any date after.
No problem. On Monday we'll accommodate him.
Just that small amount.
Let's start at least. Let's start at 12. Only there is Mr. Subramaniam. No.
Monday.
So let Mr. Sival complete the argument, then we shall see how we can marry our child.
Subject to the permission of Honorable the Chief Justice. Matter be listed on Monday, coming Monday at 2 p.m.
8. Monday means 8.
Yes, Monday is the 8th. Yes.
Yeah, good go.
Flash.
Not Mr. Sipal. Has this been uploaded? Yeah, just upload. But just upload it.
This comprises all our services.
Thank you. सारी फाइल मैं आपसे पहले बोल रहा था एकदम
I'm seeking a short accommodation for
70 0. What is it?
I'm seeking a short accommodation for 2 days, and arguing also is out of the exam.
What is the matter? Let us see.
That 302.
He was discharged by the trial court. The High Court has set aside. He remanded the case for a fresh trial. That's all.
On his request, when do you want?
My God, Wednesday or Thursday.
Thursday. This coming Thursday.
71.
The report also indicates that similar matters are pending. The order is at page 63 minutes.
Yes.
Same order. Same FIR.
Yes. ये जो page 63 वाला order है वो पास कर दीजिएगा, tag कर दीजिए. Just one miss call one.
With the criminal case number, I'll give you the court master. That will have to be changed.
Give the case number. ये page 63 वाला जो order है वो ये होगा case number वाला.
Item 73.
Yes, please.
My lords, may just have looked at 2 pages, my lords, before going to the review of judgment, my lords. First, may I have looked at page number 30.
Yes, please.
This is, my lords, the circular dated 7th of December 2001. My lords, may permit me to read only the first paragraph. I am directed to state that the proposal for providing incentives to the group for scientists in order to attract, retain, inspire, and motivate scientists to give their best contribution on the pattern of the same being given to the scientists in DRDO as per the conference given by the Minister of Finance, who was placed before the governing body at its 150th meeting held on 15th February 2001. The governing body considered the matter and approved to grant the following incentives to group for scientists in CSIR with effect from 1/1/2001. Now, my lords, may kindly see the very first paragraph. Special pay of rupees 2,000 per month without DA to scientist group 4 in the pay scale of so and so in lieu of a separate higher pay scale after peer review. This peer review, my lords, may take note of, took place later, but the higher pay scale was given only to the scientist in DRDO and Department of Space, but not to the CSIR. Now, my lords, may kindly come after this order. The next page, my lords, may have a look at is at page number 33. And in this, my lords, may kindly permit me to read only the paragraph number 1.
Yes.
All the existing scientists, as well as those who are promoted, recruited in the scale of a pay of rupees so and so, will be, this is, my lords, the grade 4 scientists, will be automatically entitled for the special pay of 2,000 rupees without DA. The special pay will be, my lords, may kindly note, the special pay will be entirely a separate element, not to be taken into account for any purpose, as such as pay fixation, entitlement for various purposes, and specifically mentioned pension, etc. Now, these orders are for, this is up to 8th March 2002. Kindly take note of the date, my lords, at the bottom. CSIR circular 8th of March 2002. But 2001 clarified by the clarification dated 2002, continued in operation till the year 2022. People balance derived the benefits, the benefit of special allowance on the basis of this office memorandum, on the basis of this circular, accepted the benefit taken till 2022. Some officers come and they challenge it before the tribunal and say that we are entitled to the benefit of a judgment in the case of OP Nijavan, where the incentive was in view of a higher pay scale. Whereas in this case, the incentive was only an incentive. It has not been replaced by any higher pay scale. And it, both the tribunal as well as the High Court matters are mechanically followed.
Where is the stand before the tribunal?
That
this stand, which you are taking, page 33.
Page 33. These are all part of the record matter.
Here is your pleadings.
But there is no pleading to the effect by the applicants before the tribunal.
By you?
Yes, madam.
Where is the reply? Before the High Court?
Yes. That reply is not in the book.
Before the High Court, you had.
But the reply has not been filed here. If permit me, I'll file that reply.
No.
But the fact remains.
Gentlemen, just a minute.
Yes.
You filed a writ in the High Court.
Yes, madam.
Where is the ground in the High Court?
Madam, that has not been filed.
Where is that ground?
My lords, they have not filed it.
I have not filed it.
We know they have not filed it.
Yes, my lord.
You have a copy of the writ here?
No, my lord.
We have it on a soft copy.
Have they taken this as a ground?
No, my lord, they have not.
Fresh case, my lord.
Yes, yes, ma'am.
No notice has been issued.
Otherwise, also.
So it was adjourned on.
My lord, Mr. Bala Subramaniam was not well.
Okay.
Therefore, my lord, sorry.
You are there now?
Yes, my lord.
Accepts notice on behalf of the respondents.
My lord, just one.
Just one. What's your good name, sir?
My lord, my name is A.K. Behera, my lord.
Shri A.K. Mehra.
Behera.
Behra. Invites our attention to the circular dated 8th of March 2002, bracket में page 33, as also communication dated circular at page, what is the date?
Page 30, 7th December 2001.
December 2001.
Yes, sir.
उल्टा कर दीजिएगा. 7th of December 2001, page 30 as also 8th of March 2002. In support of the submissions that what was accorded to the scientists was a special pay not to be taken into account for the purposes of computation of pension.
Yes.
Correct?
Yes.
Yes, sir.
And this was, my lord, accepted by the respondents for all these years till 2000.
That doesn't matter. Whereas in OP, whereas this court in 2020, volume 14, SCC 420 was dealing with a case where
my lord, this special pay was in lieu of a higher pay scale.
Special pay was in lieu of
a higher pay scale.
Higher pay scale.
Yes. Whereas in my case, my lord,
hence the High Court erred on relying upon the ratio laid down in OP Nijavan Supra. That's your contention.
Yes.
Notice, then reply within 2 weeks, rejoinder 1 week. The petitioner is at liberty to place on record copy of the pleadings.
Lots of issues. I don't know. I can't oppose it now. But squarely covered by OP Nijavan. In fact, my lord, he's made a wrong statement before, my lord.
He's made a wrong statement, then he'll suffer the consequence.
Even factually, on page 30, my lordships, even in this case, it is in lieu of higher pay scale. OP Nijavan has squarely covered it. In fact, my lordships can just have a look at for a moment. Page 30, my lordships can look at Roman 1. In lieu of separate higher pay scale and peer review. And this is exactly covered, then I just make exactly covered by OP Nijavan. Secondly, my lordships, his prayer before the Honorable High Court, our prayer before the Honorable High Court even before CAT was only with regard to.
We were wanting you to show us that you did.
My lords, 96 people have been given. On parity is what we moved this petition. This order is here. And this order waited for OP Nijavan to come up. So today they can't create a confusion before my lordship.
That's in this matter, where my lord can say in lieu of the separate higher pay scale after a peer review. In this matter, no peer review took place, only in the case of DRDO and Department of Space.
Yes, yes. I'll place it. Otherwise, there is nothing in this matter, my lord. Just one second. Huh?
You have
page number 72. Page 72, the rate is also there, my lord.
Nijavan Malad is annexed to
whether in Nijavan also.
Yes, my lord.
After this similar notification, the circular of 7/12/2001.
Yes, my lords.
8/3/2002 clarification.
My lords, Nijavan.
There in Nijavan also.
Yes, my lord. I'll just explain, my lords. What happened?
Gentlemen, we are asking this Nijavan.
Yes, Nijavan has been annexed, my lordships.
At page 40, madam.
40.
And my lordships, this issue which crops up in this particular case has been dealt para 33 onwards, page 54 of Nijavan, my lords.
No, this clarification.
Yes, my lord.
Was available in Nijavan also?
No.
My lords, even I'll just explain, my lords, just what was before Nijavan, my lords, before this honorable court, was the issue was whether any special pay has to be added with pay for the purposes of pension with regard to the fundamental rules 925, what was being interpreted. There also, my lordships, what this honorable court did was it held that look, as far as special pay is concerned, if it is given in lieu of higher pay scale, then effectively it would be counted for the purposes of pension para 33 onwards, right up till 37, this has been dealt with squarely. Now, this issue has been dealt with. And in fact, 97 people from CSIR have been given this benefit.
36.
1 minute, gentlemen. There are 23. Similar notification.
Yes, my lords. Page 50, para 23, identical notification, my lordships. In lieu of separate higher pay scale after peer review. My lordships can see it's called out 3rd February 1999. And 96 people from CSIR have been given this benefit, my lordships.
Where is the similar clarification?
My lordship, page 20, para 23, page 50, Nijavan.
No, Nijavan is there.
Yes, my lords.
After peer review is also mentioned.
Yes, my lordship. And in lieu of separate higher pay scale. Similar issue. Yes, my lord.
But thereafter.
Yes, my lords.
In our case, he is pointing out to the clarification of 8th March.
My lordship, only a
similar clarification.
Only
was also in consideration.
There was no, my lords, there is some confusion being created. The only issue, my
it's not creating. It is a document.
No, I mean with the documents.
Query is very simple, Mr. Counsel. What is your name?
Vivek Chib, my lord.
Mr. Vivek.
Yes,
query is very simple. Para 23, we have seen that is a document at page 30.
Yes, my lords.
Was Nijavan also dealing with a document at page 33 is what our query is.
My lord, para 24, my lord. Just below that. Special pay will not be treated as pay for purposes like DA, HRA, etc., which led to filing of original applications in CAT, questioning the clarificatory order issued by Government of India. My lord, I am making a statement. This was squarely covered.
This was in the query only.
Yes, sir.
Yeah. See, either we are not understanding, then you can raise your voice.
No.
If we are understanding, we are. Mr. Counsel.
Here, kindly have a look at page number paragraph number 36.
We have
what the
page 50, para 23 and 24.
Yes.
Deals with identical communication which you have invited our attention to at page 30 and 33.
Yes.
Now, tell us.
Now, my lords, I draw my lord's attention to para 36 of the same judgment.
Dismiss.
Obliged.
Para 36, now.
Thank you.
Page number 55.
Thank you. Dismiss.
Item 74.
Obliged.
Lord, item 74 is a fresh petition I noticed there's no clarity in the SLP. I'm praying for 2 weeks' time to file an additional affidavit.
To withdraw it and file a letter with liberty. Seeks permission to withdraw the present petition, reserving liberty to file afresh on the same and subsequent cause of action with petition.
I'll do that. Grateful.
Liberty as president.
Please, Your Lordship. What's both of them are living separately since last almost 40 years.
We cannot help you, sir. Only if you want to explore the possibility of settlement, that's the only thing.
Lordship may.
There's nothing in it.
Yes, Lordship may refer to mediation.
No. Today we have not even issued notice. How can we refer to mediation?
Some sort of mediation because she is living separately since last.
Only for exploring the possibility of only notice confined only for exploring the possibility of settlement.
He's ready for some one-time settlement. So I have taken.
Bolana settlement.
Please. It's delay of 60 days.
Delay no.
Lord, on item 76, on the last occasion, my lord had granted me liberty to file an additional affidavit. I filed IA. Along with that, I filed the judgment of the Rajasthan High Court. My lord, may kindly have page 15.
What does the judgment say?
This judgment says, my lord, that placement in the upgraded post will be treated as promotion and offset against entitlement against ACP, Assured Career Progression Scheme. And this judgment was in our favor. And at page 16, my lords have dismissed, I have placed the order of this honorable court. My lords have dismissed the SLP in my favor. So if I may straight away request my lords to have P4. This is the clarification which clinches the whole issue, my lord. P4 at page 127, my lord.
One
127, my lord.
Yes.
It starts from 121. My lord, may have 121. And the relevant clarification, my lord, is at page 127. Bottom, my lord. Serial number 31.
Why did we not issue notice?
My lord, because on the last date, I wanted to place the judgment of the Rajasthan High Court and my lord's order. That's why. Now I have placed it, my lord. Although the office report stated there was some confusion, my lord, office report says SLP dismissed, but that was SLP dismissed in my favor.
That was an SLP of the private individual.
Yes, my lord.
Your Lordship.
So that was in my favor, my lord.
Your Lordship, in page D of the list of dates, they have referred to a judgment in the case of Beneath Kumar, Union of India versus Beneath Kumar. In that case, Your Lordship, the judgment of the Patna High Court clearly relied upon this judgment, Your Lordship. That was placed before the Honorable High Court, which is not placed before the before Your Lordship.
What we do is...
And Your Lordship, that judgment has been affirmed by this Honorable Court. The judgment in Beneath Kumar's case, SLP has been dismissed. Kindly see this. Page 36. Page 36 is the judgment. I placed it before the Honorable High Court.
1 minute, 1 minute. You are respondent number?
And for the respondents, Your Lordship, for the private respondents. Yes, Your Lordship.
Accepts notice on behalf of all the respondents. She submits that the
judgment, Your Lordship, it starts at page 31.
1 minute.
Yes. Page 20.
Delivered by the High Court of Patna.
Page 26. Page 26, Your Lordship. It starts from page 26. And the relevant is at page 36.
And delivered by the High Court of Judicial at Patna. Stands, which in effect is in favor of the private respondents, stands affirmed by this court with the dismissal of the SLP. The SLP number is please.
And Your Lordship, page 36 clearly refers to this judgment. Yes, yes.
Whereas on the other hand, the NDAG submits that position to the contrary taken by the ratio of law, contrary to that of the one laid down by the High Court of Patna, stands laid down by the High Court of Judicature at Rajasthan, bench at Jaipur in case number so and so. SLP arising therefrom preferred by the private respondents, by the private person stand dismissed by this court in the SLP number so and so.
Stay over there. They have filed.
1 minute, 1 minute.
And your lordship, also page 36, your lordship.
1 minute, ma'am, we are issued notice, we'll hear you.
Yes.
What we are doing is, as let the private respondents file reply within 2 weeks, under 1 week. In 2 weeks, kal lijiyega. In the meanwhile, no proceeding of contempt shall be precipitated by the private respondents.
Yeah, your lordship.
We state the proceedings of proceeding in the contempt initiated by the
respondent. Your lordship, at least look at page 36, your lordship, for a moment, your lordship.
You want
page 36.
You want us to dismiss it today? We will not do that.
No, your lordship will not. But
we want to see.
Yes.
2 courts have taken a different view. 3 courts have taken.
No, your lordship. There are in fact 4 high courts which have held in my favor, confirmed by this honourable court. And your lordship, it is not just a simple dismissal.
On the next day, it will be dismissed.
Your lordship, just 1 minute for my satisfaction, your lordship. Yes. Page 36.
Yes. Yes, please continue.
Yeah. Further, CAT principal bench in OA number so and so again considered the same issue, and by order dated so and so, it held as under. We've heard both sides and have perused the material on record. The basic contention of the applicants is that they are squarely covered by the judgment of Chennai bench of the tribunal in OA number so and so. This order has been upheld by the Honorable High Court of Madras, and SLP file against the same has also been dismissed by the Honorable Supreme Court. The applicants have therefore prayed that they be extended the same benefit as was given to the applicants in the aforesaid OA. The respondents on their part have not denied the applicants are similarly placed as the applicants in OA number 335 of 2007. They have simply stated that OA number so and so may not be treated as a precedent since it is an order per imperium. In our opinion, this contention of the respondents cannot be accepted. Is your lordship giving a fixed date for the
October.
In this matter, the Honorable High Court has observed that secretly recorded communication cannot be filed. The latest judgment of your lordship. In that, so therefore, that is what I'm saying to the Honorable High Court.
No, that is between husband and wife.
Because in otherwise also.
No.
There were 2 questions.
No.
Because if I can,
it can never be.
Please, no, that's what follows. If I can.
Otherwise, government will privately record your conversation, and government will place it as evidence in every trial.
If I can only file
in every trial, there will be you see, even without you knowing, there will be a proof of conspiracy in every matter.
Civil case would be different. So therefore, what happened?
This was between husband and wife.
That was between husband and wife.
Yes.
But then also there were 2 questions.
Civil proceedings. You record something in your pen. It is that pen camera matter, no?
Please.
You record something in your pen camera during mediation proceeding, and now you want that what conversation was recorded during mediation proceedings should be treated as evidence in court.
It was a panchayat.
Never be. Never. Mediation. Can never be.
But that judgment says
that is a wrong reliance on your part.
Plus, there are 3
that can never be relied. Private conversation in behind the back of a party can never be treated as evidence. That too in a device.
Plus, that's what was it. I cannot read the questions. But the question is whether a secretly recorded conversation can be permitted to be given in evidence. And then thereafter Because the first question was something I said.
This 2005 civil suit, no? That
was 2005, but
another SLP, 2 SLP.
Yes, the other one rejected.
You got it adjourned. Yes, but the other one was received.
Absolutely nothing. Plus, may allow me. Allow me 1 minute. Plus, if I can cite the judgment only.
Yes.
Yes.
You can introduce me. Accompanying offences, these SLP is becoming.
But should be, that should be offence while the petitioner is compounded before the trial court. If I may just pass on the order in the application filed.
Some settlement was going on?
Settlement was entered into. In the meantime, they've compounded the offences for the petitioner.
Then that's the end of the
Infructuous. This is infructuous.
This is infructuous.
SLP is infructuous. It is already recorded or it is orders are passed
The
or
order is passed. The order date is 25th of August on page 1, not sure.
Invite sir has placed on record order dated 25th of August 2025, passed by the court of passed by Judicial Magistrate First Class Ludhiana. In the order reads as under. We'll extract the order. Be of the same. He does not press the present. For the same to have become infructuous.
May I please, Milords? If Milords may recall, Milords had asked the husband and the wife to be here, Milord. The allegation is under POCSO. They got married at the very moment. And the complainant was the mother. So Milords had asked us to get them to the court. Milords, both of them are there. Against the wife as well as the husband's there, Milords.
Husband is also there.
So Milords wanted to see, Milords. We are praying for quashing, Milords, in this, Milords.
Trial, what is the stage of trial?
Milords, the charges were framed, Milords. Thereafter, there was a stay, Milords, and it has to start, Milords. She still has to give her evidence.
1 minute. Have you joined Ms. Ruchira? There's one behind you. You joined the bar? Ruti, you joined the bar? You with whom? Confirm. We request Shri Sanjay Jain, Senior Advocate, to assist the court as amicus. Just give your name and particulars also. Huh? Name, address, your name, your address, your email ID, your phone number. Shall assist the University Council. Also as amicus. Shall assist us. Then assist both the learned amicus and also also us. Then the registry is directed to supply complete paperwork to the learned amicus within a period of, in a digital form, within a period of 2 days. Registrar Judicial shall ensure compliance. Then list on dash.
If I may request, Milords, then if Milords is...
1 minute.
Sorry,
Milords. 1 minute. Shri Sharma submits that the Complainant, ये कहाँ से आया है?
गुजरात से।
I appear for victim R2 minutes.
Gujarat, my lords.
You appear for the girl.
Yes, for the girl,
For the victim.
1 minute.
from Gujarat.
You have verified their identity?
Yes, I am.
They have Aadhaar card and all that.
Yes,
Yes, my lords.
You retain it and
My lords, they may be permitted to join online if my lords for the next data.
Just a minute. You do one thing. You're in some matter here. Are you in some matter here? No. Just go out, talk to the lady. It's a case of POXO where they're remarried. Mother is the complainant. Go out, talk to her. Vernacular language. And ask her whether voluntarily she is, chosen to now reside with him or she is.
two things, whether she has married and whether the marriage is successful and still continuously staying with her husband out of her own free will. That two things.
Very well.
We just pass it. आप क्या करते हैं? हाँ? किधर है दुकान?
He is running a shop of tire.
ठीक है, अभी थोड़ी देर में लेंगे आप क्या नाम है मैडम?
Komal.
आप इनके साथ जाइएगा, बातचीत करके वापस।
My lords, just passing it over, my lords.
Passing.
Obliged, my lords.
Item 80.
Yes, 80.
Your Lordship, pursuant to Your Lordship's last direction, we have filed the additional documents with all the particulars, specifically the cases regarding the constitutionality which are pending. And if Your Lordship may permit, I am praying for some time because there are aspects we would like to cover and research upon.
Okay. We'll have it some other day.
Lordship may give me 2 weeks time.
I am told that, in fact, I was reading somewhere, Honorable the CJI has also issued notice in one matter.
Yeah, Lord, as per my information, that is true, but that is with regards to the specific issue of confiscation.
Okay. So we'll have it on some day.
Lordship may give me 2 weeks, that would be great.
Why Monday?
My Lordship, there are certain aspects that we wanted to research upon, and that's what we
Monday.
My Lordship, Friday if possible. We are led by Mr. Justice Ashwini Kumar Singh.
Friday the court is closed.
Friday 12th of September. 5th is the holiday.
We'll have it on Monday and we'll see.
Very much. Much obliged.
Much. My Lordship, actually Justice Ashwini Kumar Singh is not available on Monday. That is why.
We'll adjourn it that day, don't worry.
Much of.
There's a reason why we have seen.
Much of it.
ये नोट करना चाहिए। इसको कॉपी करके केवल ये कॉपी करके हम ये सारा कॉपी करके हम चलाएं बाकी इसके
Please, Item 81 for the petition.
Yes.
During last hearing, Lordship actually allowed the petition and gave adjournment only for the counter to be placed.
You have filed our counter status already filed the counter.
Yes.
It's a case of forging of birth certification. Last time, Lordship almost allowed the SLP and said let the counter be placed on record. Page number.
What do you say here?
Lordship, your Lordship see complaint, page number 20. There is no whisper of forging the birth certificate, Lordship. Kindly see page number 20, the complaint filed before the Judicial Magistrate under section 156(3). It only discusses about the children age, whether the children has
page 20 of your contract.
No, the SLP paper book.
20 is something else.
24, I'm sorry, 24.
Yes.
Kindly read this complaint, Your Lordship. The complaint nowhere says that there is a forging of birth certificate, Your Lordship. It only says that as per the government rule, kindly see page number 26. as per the government rule, those born between so-and-so to so-and-so in class number 5. Lastly, Lordship, those who born on 1/8/2016 to 31/7/2017 in class number 1. And the magistrate order, Lordship, it categorically says, apart from this complaint, he has not produced a single piece of evidence to show that the birth certificate was.
Page 25, last paragraph, as I have clearly stated about the forgery, my lords. Page number 25, last paragraph, my lords.
Who has forged?
Lords, the government, the respondents, the complaint respondents, my lords. The administrators of a school have forged the birth certificates of the students, my lords, children, my lords.
It doesn't say so, Lordship. Page number 25.
Last page 25, last paragraph.
You are the school.
No, Lordship. Is the other school
competing school, and he has an interest in the outcome.
Whether it is interest or not, my lords, the very crux of the matter, my lords.
Because they have the
What is going on about there is a forgery in the date of birth in the birth certificates to make sure that they have more students in their to show more students and get more aid from the.
Actually, my lord, single document producer, Lordship. Kindly see.
It is not such a simple.
No, Lordship. Kindly see page number 30 of this complaint. What are the documents he has produced, Lordship? He has not produced any forged document. No, even magistrate dismissed saying that he has not produced any document to show that there was a forgery. Kindly see page number 31, the magistrate order, and kindly see page number 36. Third line from top, Your Lordship, but nothing has been said by the petitioner as to whether admission of such underage children to the school is defined as a punishable offence as per.
But if you see the complaint at page 26,
25 to 26.
The following students have been admitted to the school by the headmistress in violation of the government rules as per the list. As per the government rules, born between 1st of August 12 to 13 in class 5, 3, 4, 5, 8. And then she has given details, number of students.
Yes, so Lordship, in this case, if this is often, this is the school education department has to take a call on investigate this matter, Lordship. A criminal case. So this case is the parents have forged, the school has forged the birth certificate, Lordship.
Both. Twin allegations, Lordship.
No, but see, the simple is he has a complaint.
Yes.
He give particulars.
Right.
Now the magistrate said that it's not a case for investigation.
Yes, sir, because Your Lordship, no document produced to show that the document, the birth certificate was forged in this by the school.
He has given the particulars.
No, he has not given the particular, Lordship. These are the date of birth of the children who have joined early. So if that is the offence, the school education department has to conduct the investigation, not the police department. This is not a cognizable offence, Your Lordship. It is not that the school has forged the date of birth certificate. Say, for example, if the child is born on particular date, somebody forged that birth certificate and filed it to the school and joined the children later or before.
That will come in the investigation, that the police has to investigate.
This is at the stage of 156(3).
156(3).
How can you expect yes to produce the entire evidence which is in the occupation of the district education officer?
Investigation officer.
He was in position of.
My lords, a point I would like to make for respondents 1, 2, and 3, if my lords permits. My lords, respondent 1 is the principal, the headmaster of the panchayat school, and this is not an aided school. It's a panchayat school wholly run by the government. So there is no question.
The government body.
The panchayat school is a government school. Yes, there cannot be a question of aid and its usurpation and using these data for getting additional funds. Yes,
not a government school.
It's a panchayat-run government school.
No, but it was receiving grant.
The competing school is a granted school. The school that receives grants. It's a panchayat school wholly run by the government. It does not depend on grants, my lords. It is run by the state. So there cannot be a question of a motivation where they can seek some additional admissions, and on the basis of that they would get additional grants.
So this Panchayat Union Primary School is not a private school.
Yes, my lords. Yes, my lords.
Plus there is
And there are inquiries going on against the school in which he's employed, and he's a disgruntled element, my lords. That's all I can say.
It's a criminal inquiry also, my lords. But can you kindly read page number 46 wrong?
We are not adjourning the matter.
Arbitration.
We are not adjourning.
No, I am not on. In this matter, petitioner has died, and his wife and only son is brought on record about.
Then
on the wide order,
we were not inclined to issue allow the petition. Only we thought that you could pay market price.
Yes, I am ready to. As per their policy, the price is not even a lease deed. In the petition, he has made false statement that lease deed is executed. Lease deed is not executed. No possession even has been given to him. He was supposed to pay certain money. No. In fact, your lordship said it on the last occasion. In fact, your lordship only 11. Complete, and it's a false statement, Lord. Please see the representation which he makes.
Thank you, sir. Thank
Your
you.
lordship, I am ready to pay as per their policy.
Gentlemen, we were okay. Current market price will pay and take it. Simple.
Wide ordered at 8.4.
Current market price will pay.
You'll auction it again. You'll auction.
No, I auction.
Lordship, as per the nothing and complete false statements. As per the civilized grateful. Lordship, last time the regional manager was directed your lordship.
Okay, thank you. Yes. Yes, please.
My lord, sir. Of my lord, maintainability of the suit to the bar of 34 months. There is an application for seeking to substitute the respondent number 1, but your lordship was not inclined on the last occasion. The admitted, my lord, is a declaratory suit seeking right title and joint constructive possession. Without, my lords, the prayer of partition or recovery of possession. Admittedly, they are out of possession. The trial court takes the view that section 34 proviso will be barred, and therefore it is not maintainable.
Correct.
High Court takes the view that provisos of section 34 is not exhaustive, and you can take aid of order 2, rule 2. My lord's judgment of your lordship.
Yes.
Right.
Yes.
So far as, my lords, if it is case of title without prayer for possession, your lordship's judgment is there, Vasanta, all along. Law is very clear. Now, this is a grey area where joint possession is sought. Now, AIR 60, this issue was propped up, but the court didn't go into it. My lords, in a whether partition amounts to further consequential relief. And that is an issue. Guwahati High Court has taken a view, but there is no direct Supreme Court judgment. But even when they amended, they didn't.
Are you ready for some settlement or not? Simple as that.
At my lords, we can try our luck.
Otherwise, we are not looking.
So, my lords, if what falls from your lordship, we'll have to abide. We'll try our luck.
No, there's no question of abiding. We are only we are indicating.
Ultimately, my lords, they are relatives fighting.
Therefore, because we are not with you, let us be very clear.
High Court said ancestral property level. That's not true. What
He also doesn't get, my lords. The court doesn't say, holds that permanent injunction is not
ready for some settlement or now is the only issue.
One attempt can be made, my lord, without instruction. I can't.
Last time also I said, lordship, we are ready. They are not moving forward. So what can we do? Because in our land, their names are still mutated. It is just that they want to keep their land and not share it with us.
They have so far. There are two places. The family arrangement has been acted upon. The High Court says in the mutation proceeding, one place, one brother takes the land. I am in the other. That, your lordship, relying on Kalyan or the mutation proceeding attain finality. In
you want to argue?
No, my lord, I am responding to him. So my lord.
Very well, lordship. Last time also we had made that suggestions. But then it is for them to.
Well, one attempt, that's all, my lord. It is for the clients to, your lordship may refer it to mediation, one attempt. One.
We are not inclined to interfere with the.
That your
No,
lordship.
we'll say that.
My lord, then may I, my lord.
However,
your lordship would
only
not
for
say.
the purpose of
Your
exploring
lordship would not say because my lord, the High Court observation is, my lord, two judgments of your lordship.
Then we are very clear.
My,
You take order today itself.
your lordship may not observe. I know what falls from your lordship, so you can take it from my lord. But that I want to just satisfy your lordship. One attempt may be given to me.
Okay, prima facie we are not inclined to.
Because there are
Prima
two
facie,
judgments
no
which my lord.
Prima facie we are not inclined to it. But that gives us that
Your
tells us.
lordship, that I quite see, my lord. I would also just.
However, only for the purposes of exploring possibility. However, we considering the relationship interceding parties, we have the view that it would be prudent that the parties sit and settle the matter. At this stage, and consummate matter can be reversed immediately.
Supreme
Court.
Video, if it's if that
we say first is video, rest is that we leave it there.
So the Supreme Court
that application would your lordship, because the LRs of R1 formally.
That can be allowed. And you will represent them.
I really cannot say that process because.
I'm छोड़ दीजिए फिर LR application को pending.
Then the LR, the respondent wants LR formally has to, then they'll participate. Otherwise, if your lordship.
He convince them.
Deeply obliged.
Lordship is fixing some date for meeting. Wait for me.
Yes, please.
Being for the petitioner, we seek to withdraw the present SLP on the basis of the settlement they have done and the order which has been passed by the district court on page number 9 of the IA.
Seeks permission to withdraw the present petition.
Please.
Should we fix this matter for final hearing? Is this, there's already an interim order now, so this needs to be.
Lord's, a letter has been circulated.
Letter is not there, but doesn't matter. When do you want?
Lordship may have it in second week of October or whatever after the Shara holidays.
As prayed.
What should like Lordship?
The pursuant to Lordship's order passed on the map day, you filed a 3-page short notes.
Yes.
That's not much in dispute. But on Bhagwanya, he inherited.
Is the title suit pending or no?
Suit
Yes.
pending. He had filed a suit for cancellation.
Title
That is pending. They concede this.
Sir, we are asking you. If you want to argue, we will no different.
No, Lord.
कोई दिक्कत नहीं है आप ऐसे करिए.
I am sorry, Lord.
They filed a suit for
Is the
cancellation.
title suit pending or no?
Pending, that suit is still pending.
Then
I submit that unless my gift deed, my waiver is set aside, cancelled, but they have no right to dispute my suit. Bhagwanya did not dispute. Bhagwanya was the owner. Now she executed a gift by waiver.
Then a writ court will set aside your gift.
No, it was not set aside.
Then this is it.
No, not earlier.
Thank you.
Not kindly. That is the case, my lord.
Open for the parties to take all pleas before in the title suit which is pending interceding parties.
Very good. That's it.
Yes, sir.
Who's arguing for the respondent?
Who's for the petitioner?
Lordship said refer this matter.
Mr. Nair, kindly unmute yourself, please. Kindly unmute yourself, sir. Unmute. आपकी तरफ से मैं अनम्यूट करना पड़ेगा मिस्टर नायर.
Right, sir. सुनाई दे रहे सर?
हाँ, please, we can hear you.
Yes, sir.
Lordship said refer this matter to mediation.
What happened?
It did not go through. We filed an application for substitution on behalf of the respondent number 1.
Let him argue.
Yes.
Yes, Mr. Nair, you are arguing yourself?
Yes, sir. Yes, your lordship.
No, your counsel is there, Ashok.
Sir, I am arguing myself, sir.
Okay, then proceed.
Sir, your lordship had ordered for mediation, sir. The company has not agreed to anything, sir. Only what the High Court order has given, sir.
Earlier, it was dismissed by the High Court, not correct?
Yes, sir. They said that what the district court, first appeal court has agreed, only that will be agreed to, sir.
And you are the appellant before the High Court in your second appeal.
Yes,
your
sir.
second appeal has also been dismissed. Now,
Yes, sir.
tell us what is wrong with the finding by the High Court.
So the trial court had given in my favor, sir, and found that the allegations against me, serious charges and all, are utterly false and illegal, sir. So, the company thereafter went on appeal, sir, and the trial court gave me a compensation of 50 lakhs for the stigma that this has created, sir. There, I am a double decorated soldier retired from the army, sir, and joined them when they offered me the job as head of security, head of the department in 2007-16 August, sir. And I served with them almost 6 years, sir, till they suddenly terminated me on 2013 February, sir.
But are you a workman?
Pardon, sir?
Are you a workman?
I am a veteran, sir. Colonel with 2 decorations, sir.
The legal court has not done it. It was a reversal. Reversal.
Sena Medal and Chief Citation, sir. Is given in page 49-51, sir.
Trial court said 50 lakhs. He is entitled to 50 lakhs. The court says 5. First appeal court says 5,95,000.
Lordships, in this matter, firstly, my lords, it's incorrect to say that we were offering only what the High Court has suggested. What has transpired is that the petitioner had in fact approached the labor officer, district labor officer, after his termination, assuming that he's a workman. The labor officer was not passing any order, so on account of the delay in passing the order, he approached the High Court by way of a writ petition. That order, my lords, is at page number 1.
We have seen that.
Yes, the High Court directs that, without commenting on whether he's a workman or not, directs him to take the statutory remedy that is available to him, since he himself had approached the labor officer. He does not do that, goes in the civil suit. The civil suit is decreed not in his favor, so to speak, because the compensation was granted, which was not really paid for. In the first appeal, my lords, the court says that the terms and conditions were very clear that if you are terminated without notice, you will be paid 2 months' salary. So around 5,91,000 was decreed in his favor, my lords. Not in his favor. The amount was reduced. He carried it in appeal in the High Court and did not succeed, my lords. So 2 concurrent findings are there against him. As far as the amount is concerned, the amount specifically what the terms and conditions at the time of hiring was stated, that amount has been awarded and we are ready and willing to pay. We have in fact written a letter to him after the first appellate court's order asking him to collect the amount with interest.
So, Your Honor, that is not entirely correct. These
1 minute. Just give us a minute. Why was the suit not maintainable?
The suit, the issue of maintainability was raised because the High Court had directed him to go to the appellate forum before the labor industrial court.
Therefore, the query put to him, was he a workman, who is put to you?
Yes, my lord.
Is he a workman?
My lord, we are saying that issue has not been decided now.
He can't be a workman. No?
He is not a workman. Because he is security.
Therefore, that
I'm not stating anything on this. In fact, the main plank of the petitioner has been that he was working in a public company. So to speak, my lord, it's a government-owned company, which is incorrect.
Today you are, what is your annual turnover? You are a listed company?
My lord, this company is, yes, my lord, this is a
listed company.
Yes.
He's a decorated soldier.
My lord, in fact,
he's asking for 50 lakh rupees.
My lord, in fact, we had offered to double the amount that was ordered by the High Court.
So you are doing charity?
No, not. My lord, the allegations were serious. My lord. If I can place a counter on record, there were allegations of theft, of supporting theft from the company premises. Otherwise, my lords, it is not something that was done out of turn to harass an individual.
Sir, that's utterly false, sir. Utterly false.
1 minute, Mr. Nayak. In your written statement, have you Where have you leveled these allegations?
Now there is an inspection report which has been filed by.
They pay some amount, reasonable, handsome amount to him. We can away with it.
Lordship will give me some time then.
Mr. Nair, what's a reasonable amount?
Sir, the trial court has given a very limited amount, 50 lakhs. Sir. I have lost almost 1 crore with them, sir, 3 years before superannuation, sir. And he's granted about 50% of it, sir. So it should be something near what I have lost, actually, sir. And the sheer stigma, sir. There's no evidence at all against me, sir.
Mr. Nair.
Sir.
We propose to a lump sum figure of lump sum settling all claims 25 lakh rupees.
Okay, so your lordship, whatever you feel like.
Instructions. Lordships may have it next week.
And sir, I should not go to the company to collect it, sir. They should say.
1 minute, please.
Now the only reason I'm asking for some time is because it's a listed company, some approvals may be required. The officer, I'm only speaking to a legal officer. He may not be in a position at the board level. I'm only asking for a week's time. I'll come back with instructions. There's no difficulty.
You are instructed by a company?
There's a legal officer.
Is a law firm or
No, I'm individually I'm appearing. There's no law firm.
This combination is sitting on Monday, so we'll have it on Monday.
Very good.
They are 2 p.
I'll take it. 25 lakhs.
Lump sum, you'll have to, within 2 weeks, you'll have to remit it into his
bank account. Yes, sir. Thank you very much for that.
In the meantime, there is an application for substitution. If that may be allowed, because the correct company needs to be on record.
No, sir. Yes, it should not be, sir.
My learned petitioner may also indicate if he is agreeable on that day.
He said this.
If he's okay,
that's it. Lump sum. Mr. Nair, lump sum figure.
Sir, you, sir, your lordship had agreed on 25 lakhs, sir. It is agreeable to me, sir. They should pay into my bank account, sir. I don't have to, should not go to the company, sir.
Don't worry.
Grateful.
Thank you, sir.
इसको दो. So then in Monday we'll have combination. इसलिए 2 p.
Item 88.
Yes, my lord.
Well, it's, I beg to appear for the petition.
Just one minute.
Please, my lord.
Yes, please.
Malach, we were served a copy of the counter affidavit on Saturday night. Therefore, we are seeking time to file a rejoinder. And Malach, we also.
You are the.
Yes.
No, rejoinder for what? Why did we use
Malach, they have relied on certain.
Forget about their counter. Why did we issue notice? See, quite often we issue notice for several reasons.
Yes, Malach, but after they did not agree for the mediation, Malach had issued notice in the matter. So, Malach, there are certain testimonies.
The court said time is the essence, whereas when we look at the agreement, time is not the essence, as has been held by the first appellate court as also the second appellate court.
But Malach, trial court, it observed in my favor.
We know that, I told you.
But Malach, it even went on to say that they had produced certain documents which were torn. They had used the document for their advantage. They had to torn the page just to make out a case.
Trial court, my gentleman, trial court also said that the plaintiff was ready and willing, mind you. So that issue was that 1 minute. The agreement existence, validity, and readiness and willingness was held by the trial court against you also. And all concurrently thereafter, sorry,
My lords, on 8th of February 2000.
Thank you.
My
Thank
lords,
you.
my lords, may at least give me a
We told you.
only a week's time, my lords.
No, we are not even relying on the counter. We are not reading the counter. Thank you. But thank you. Dismiss.
Wait, please, my lords. My lords, in this matter, the petitioner was a minor at the time of exit. He suffered 50% permanent disability. Lordship, the Honorable High Court has granted only 4,65,000.
1 minute, gentlemen. Yes, ma'am.
Yes, my lords. My lordship may kindly see this is a 2013 impugned order, my lords, which has been challenged in 2020.
1 minute. What we propose to do is that the disability is 50%, there is no doubt about it. Correct? Multiplier has to be 18, there is also no doubt about it.
My lords, they right. My lordship may kindly see the matter was argued on the basis of Master Mallikarjun case, my lords, at that time. The what was asked for, what was argued for has been granted. My lord, it cannot be re-agitated now, my lords, after it is being.
Thank you. Please go.
Your lordship may kindly see, my lords, even the age given is a blatant line, lords. Throughout the SLP says it is, he was 3 years at the time of the accident.
But not here.
There won't
Today's date.
Your lordship may kindly permit me to just point out one document, my lords. Your lordship may kindly see.
Good chap here needs.
Well, it's not. Well, it's after so many years re-agitating the two on the basis of the.
What is just fair and reasonable.
Well, the appeal was not pending, my lords. It was fully closed. He had taken the amount, whatever he had argued for was granted.
Thank you.
The matter was closed, my lords. My lords, your lordship may kindly see this will open floodgates, my lords. Tomorrow all the child victims will come saying that.
They must get their due. What is wrong with it?
Well, it's after so many years saying that my father did not know that there was Supreme Court which can be.
They must get their due. What is wrong with it?
On the basis of the judgments which is passed on today, my lords.
Why not?
10-15 years back, the matter has been closed. Because today they are given.
This court has only reiterated the position what it existed. That's about all.
Well, it's my humble submission is Master's Mallikarjun case. Even today it has been referred to everyone. And he is argued on that case.
Thank you.
I'm so grateful to my lords.
Next case.
Lordship, in item 20, mediation failed, Lordship.
Mediation has failed. Huh?
Lordship, after this, Lordship, the child has been taken by the mother. Thereafter, no interaction. The child was never given to the father or father's parent. And your lordship, and they were not even appearing before the family court, lordship. Not even complying with the impugned judgment, your lordship.
Settlement is not possible.
Not, lordship. We tried for a reunion, but they were not willing, your lordship.
Because then we'll hear it.
Lordship, this is the last order, lordship. At least the impugned order may be complied.
Lords, may I suggest one thing, my lord? Not on the merits of this particular matter, but because of since 15 years, I am also a mediator for my lord's court. Means registry.
What do you want to say?
I want to say, my lords, if it is sending to the Supreme Court Mediation Center, as I am told by my local council, the Supreme Court Mediation Center, I think there is a possibility for a reunion for the betterment of this child.
Send it to the Supreme Court.
Lordship, she is not appearing before the
She appeared in all the. She appeared in 3 mediation before the High Court.
Supreme Court mediation.
Only for the best interest of the child.
At least that impugned order may be complied with. Ask them to comply with the impugned order. We may be given the custodial and visitation rights at least.
Supreme Court mediation center. Meanwhile, the impugned order shall be complied.
Wait.
Lordship, let them give an interest.
We have said the impugned order shall be complied.
Because there is a contempt petition filed before the family court.
Standard order of mediation.
I will instruct my client, my lord, to.
Yes. Yes, please.
My lord, kindly see, my lord, this honorable court has disposed of the SLP, your lordship, at page number 24, your lordship, the order is there. Your lordship.
What is this application?
Your lordship, after the disposal of this application and this amicable settlement, your lordship. Your lordship,
that after full settlement, he has filed another matter.
Your lordship, after full settlement, your lordship, there 127 petition was pending, and your lordship, the
the family court, Your Lordship, increased the maintenance amount, monthly maintenance amount, Your Lordship. Your Lordship has stated that order also.
It was, my friend possibly given the impression it's not a new one. It's not a new application. It's not a new application. This application was already pending.
What is your prayer in the application?
My friend,
My Lord, it's my application, Your Lordship.
you want to set aside
the order dated 12th of February, Your Lordship, which was passed under section 127 of CR.
You will keep on agitating and
Your Lordship, after the final settlement against all claims, Your Lordship, the order was passed
one, sir. It is a
for increase of the maintenance amount, Your Lordship, and they have filed the execution application, Your Lordship.
Sir, your right was saved under the settlement that you will apply for enhancement of the compensation.
No, my lord, may I just come to page 25?
Yes.
May page 25?
Yes, yes.
Needless to add,
till such time the
needless to
pay
continue to pay the amount of maintenance.
Ah.
So the amount of maintenance, this relates to the past one.
Full amount of 1 lakh.
10 lakh.
10 lakh.
10 lakh. 10 lakh was the total amount which was settled, and this was a past one from 12 to 22. I can understand the moment they paid December 25, things can close down. But the past one has to be cleared, and it will be difference of about 6-7 cents. In fact, I don't want to bring it to my friend's notice. The trial court has found it. I put it this way: the first came the lordship. They had a floor wheel.
He had a floor
wheel. And
1 minute. The amount total agreed to be paid was 10 lakh rupees. Correct?
Against all claims.
Now, how can you file an enhancement?
May I respond? May I respond? If lordship recollect, just consider it. Lordship from lordship follows 20 lakhs. 20 lakhs. I said, we want to close it. We want to close it.
Then what is the issue?
What he said, I don't have anything. And
then what is the issue now?
The issue now is what happened. It related to 10 lakhs. Then I had already a pending application which was over the past 8 years, from 2008 onwards, till it is to be given. Then in that case, 2005 I was given 5,000 because 5,000 was the limit.
Now 10,000.
Now 10,000.
All
The difference is 5,000 only.
All previous orders are superseded or rather they merged in the order of settlement. How can there be a separate existence?
I leave it. I can't beyond that.
When
but
we
basically
in para 1 we say towards all claims
Yes, Your
out by the petitioner.
Yes, Your Lordship.
And then in
Your Lordship, this
para
was
2 we have said full amount.
Your Lordship, I have paid 5 lakh rupees. The first installment you have already paid.
When will you pay the next 5
Your Lordship, before the next date, Your Lordship, that is the date of your on 15th.
No. We'll prepone that date.
Your Lordship, I am trying my best, Your Lordship, to get it.
We'll prepone that.
5 lakh you have paid.
5 lakh, Your Lordship, I have paid, Your Lordship, and 65,000 also paid, Your Lordship, that as per the order that we have.
Remaining 5 you'll pay by when?
Your Lordship, I am trying at the earliest opportunity, Your Lordship, I will pay, Your Lordship, because Your Lordship, I have to pay 5,000 rupees per month also.
What time you want?
In fact, Lordship, I would just say that my friend has pleaded in wrong facts because
1 minute, Mr.
Lordship. Sorry, I was going it.
When will you pay that amount? Pay it in 2 weeks' time.
No, Your Lordship,
Why
2
you
weeks.
pay the nice amount?
No, Your Lordship, this order is there, Your Lordship. I am preparing, Your Lordship, to pay out. As per the Your Lordship, this order, Your Lordship, I have already paid.
Pay it in 2 lakhs, within 2 weeks. Otherwise,
it's very difficult for me to arrange, Your Lordship. It's very difficult.
Speak, sir. I fail to understand one.
Your Lordship,
I'm sorry.
When you know that you have weak case in law,
I'm sorry.
And only because the bench is trying to help you, why should you even speak?
Your Lordship, on 24th of March, Your Lordship, I have paid them 5 lakh rupees, Your Lordship. I am arranging the next installment, Your Lordship, for that.
4 weeks.
Your Lordship, 8 weeks, Your Lordship, please. Your Lordship, please. Otherwise, Your Lordship, my client will be in difficulty, Your Lordship, and he will not abide by the order.
Remaining that 5 lakh rupees, that in terms of order dated so and so passed by this court, some of these 5 lakhs already since paid to the petition. The remaining sum of these 5 lakhs shall be paid within 4 weeks.
8 weeks, Your Lordship.
4 weeks from today. We modify the impugned, we modify our direction contained in the earlier direction of making such payment on or before 22nd of December 2025. Application disposal.
Your Lordship, the trial court order dated 12th of February 2025 may be set.
Till such time the amount is paid. Now, in the meanwhile, we say if the petitioner pays the amount within the aforesaid period, the order subject matter of the present petition shall not be. You surely will pay, na?
No, sir. Your Lordship order, Your Lordship.
Lordship, in fact, she, the lady.
Next.
I would not have just proceeded.
Next.
Right. Oblige.
उनको समझा दीजिएगा क्या हुआ है, बता दीजिएगा ना. She's not perhaps literate.
Possibly
English.
That's what I said.
Tell her, na.
We'll do it what falls from my lord. But
Next.
Deeply obliged.
Service is yet to be complete.
It's not service. They have to take steps against Arpre's case.
Deceased, but then they were not able to trace out their legal heirs. They say that they've spoken to the brother or sister who's surviving and they're contemplating.
Steps for service of unserved respondents, complete in all respect, be positively taken within a period of 3 weeks. Notice returned to, failing which will are dismissed for non-prosecution for the legal.
1990.
Much obliged, Your Lordship.
Notice in the main matter, but today only the IAS listed.
What for?
IAS, what is happening is the Lordship that issued notice and notice on the interim relief. Meanwhile, my lord, she filed an application for execution, so I'm only paying first 3 of that.
Why?
I have already paid her 32 lakhs.
So that's all right. Continue to pay.
No, I can.
Well,
she's my wife.
And daughter.
The point is not, no, it's not that.
Continue to pay.
I'll continue to pay the
payment.
The maintenance is 10,000 each. I will continue to pay 20,000.
Payment shall be payment made by the petition shall be payment made by the petition shall be subject to the outcome of the.
No. Lordship, you said 20,000 a month I'm paying. If you Lordship just have to look at the main otherwise. No, it's not that.
She's not your wife.
Wait, no, she's not. That's not the point.
Then
have a look at the High Court order.
What is the point then?
The point is that the High Court has passed an order without appreciating anything. Have a look at the High Court order. High Court order says that you pay 40 lakhs and pay 30 lakhs. What's the basis? I'm a retired man. And there is no adjudication in this. Have a look at page 4.
We have seen that.
No, but where is the adjudication? My client waits for 12 years in the High Court. It's a false appeal. Under section 96 of the CPC, please have a look at it. I'm shocked that a High Court can pass an order like that. Have a look at page 4. Where is the judgment? Have a look at page 3 and 4. I didn't want to go into all that. That's why your Lordship, you should notice. I've paid a 31 lakhs. I don't mind, but this matter cannot be sustained.
No, I में कर देगा. We are not inclined to pass any order.
But this amount is very meager for him, my lord. Grateful, my lord. Will also indicate a date so that the main matter can be heard.
We had already indicated. Why did you move this application, sir?
Why?
Then you have a duty to also.
No, I don't mind paying the 20,000 I'm paying. But she can't ask for it. She's asking. Very well, very well. Thank you. Lordship.
Yes, sir.
Your Lordships, I appear for the respondents. We've been instructed just today morning. We are filing wakalat in the course of the day, Your Lordships, in this matter. For respondents, all the 4 respondents, Your Lordships.
Then you filed your counter?
Yes, Your Lordships, I'll be filing my counter.
Well, this was contrary to the judgment of this court, whereby certain conditions had to be fulfilled. That was non-fulfillment of those conditions were there. That was not seen by the High Court. And that's how my lords issued notice and stayed the operation of the order.
I'm not able to read it. Let respondent file a counter
and wakalat.
And wakalat within how much time?
Your Lordships, wakalat will be filing in the course of the day, Your Lordships. Counter will be filing in full.
Counter shall be filed in the course of the day. Let counter be filed within how much time? 2 weeks?
Yeah, 2 weeks is sufficient.
2 weeks is kind of 1 week. In that, you just set out why we are issued notice.
All right.
It's a regular matter that it could be taken up on Wednesday. Actually, the lady is in bad shape. She is 76% handicapped.
95 guy, what was the matter? What was the matter?
It's a matter.
Divorce petition was filed for.
What was the SLP?
The SLP it is against and not a granting divorce. But on the ground of irrevocable.
We'll fix it. High Court doesn't have that power. Possibly do that.
We'll address your lordship on that because there is a 142 also which I had filed lordship.
Yes. So it's September, October.
Much of it. Item 9.
Give your way.
Application to lordship, it's a matter where this respondent has been allotted a shop by the IDA and the contract was also awarded in their favor.
So this is an application for early hearing of appeal, Miller, which is of 2023.
I have filed an application in lordship. I'm for the respondent who has filed an application for early hearing in this matter, your lordship.
Who's in possession?
No one is in possession, lordship. It's with IDA only. They have
Possession is with the writ petitioner, with the appellant.
Yes, impugn order was in our favor. Your lordship.
Who is in possession of the land?
IDA.
Not the brief.
No, there's no urgency.
Your lordship, there is an urgency. Lordship, they have, after the contract was awarded, they have issued a fresh allotment, your lordship.
November mandate.
Your lordship may grant any date in October, your lordship.
No.
Your lordship, the urgency is that your lordship, a shop keeps
Reply, please.
some date in October.
Remember, ma'am, give your. Yes, please. Yes, Ms. Kangas.
My lord, this matter concerns section 10 of the CPC. There's an earlier suit, my lords, of 2008 and a subsequent suit concerning one of the properties in the 2008 suit. In fact, the 2019 suit, which is the second suit, is through a successor.
What's wrong with the order?
In fact, my lords, I wanted to say that straight away at para 4.
Yes.
Para 4 of the impugned order says, as on today, OS 20 of 2008 is not pending. And then they expedite these IAs. These IAs were essentially, my lords, to bring.
Where are you reading?
Page 3, my lords.
As on date, I'm sorry, I'm not in.
No, item 19.
Yes.
Correct, but it's item 19 only. There are 3.
Para 4, my lords.
This court does not find any reason.
Any reason to interfere in view of the fact that as on today, OS 20 of 2008 is not pending. Now, this was because the suit had in fact abated. Thereafter, what this court does in para 5 is it expedites my IAs to set aside that abatement. Today, the abatement has been set aside. My lord. In fact, those are in the additional documents.
Okay.
There are orders. So now, my lord, section 10, the rigors of section 10 must follow. So, in fact, there is nothing wrong per se with the impugned order, but today the rigors of section 10 must follow because there is a
We'll say that you can file
fresh application. My lord may give us that direction. And would my lord consider staying the subsequent suit because it's proceeding?
High Court and your
Trial court. My lord, ask them to decide the section 10 application within time bound within a month.
Under instruction submits that at this point in time, the OS original suit number 20 of 2008
has been restored.
Stands restored.
Stands restored.
In this view of the matter, it shall be open for the writ petitioner to move to initiate such proceedings as may be so advised in accordance with law, including filing an application under section 10 of CPC. Then we are hopeful that as and when such proceedings are initiated, the court shall decide the same expeditiously in accordance.
Marshal, thank you.
Passport 22.
Yes, please.
So, set of questions of law which arise here. Just come to the book. The issue just now is on the question of maintainability. as to whether the subject appeals could be maintained at all under section 50. I'll take you to that. Section 50 is at page 58, but first may I just indicate 3 or 4 facts. The first fact is that the 3 SLP petitioners before the court are not signatories to the arbitration agreement. Please just note that. The 3 of us are not signatories to the arbitration agreement. Second,
3 of you means...
3 SLP petitioners first.
No.
Lordship may have a look at the cost title.
If we look at the cost title of the Bombay High Court,
yes.
dispute order,
Yes.
then
It's we would be your Lordship may not have a full title there.
see, the Secretariat Navroz. Sorry.
Please go to page 21. This is page 21. Your Lordship said page 21?
Yes.
Now here you have the 3 SLP petitioners, 1, 2 and 3.
Just 1 minute. Just.
Yes.
One query to you.
Yes, certainly.
It has been admitted only, no?
No, it is held to be maintainable.
You raised that objection.
I've raised the objection and maintainability has been held against me. That's the issue which has been decided by the revision bench.
Para 4, you raised, this is Navroz Survey.
Yes, expressly, but that's the only issue decided. That's the question of law. DC para 7.
Yes, Mr.
This requires consideration.
With respect, 3 things, Your Lordship. The awards in my favor for past 20 years ago. For 20 years, I haven't got a penny. We've just had rounds up and down to the Supreme Court for last 20 years, number 1. Number 2, without pending the award, the party to the arbitration, their parent, was demerged into these 3 with an attempt to deflect the money. That is how these 3 came into being. It is today settled law that a successor or an assign or a third party can also be now bound from close downwards, etc. Now, on the question of execution, the foreign awards, on the question of execution, I am saying that the parent body and now these 3 demerged bodies have to bear the cost because they have to pay me. Now, what the court has done, I am executing against all 4 of them. The division bench, single judge held against me. I went in appeal. The division bench on their plea has only admitted the appeal and held the appeal to be maintainable against them. All other questions are left open. All other questions are left open. The appeal is held to be maintainable against the parent and the demerged entities. How long will this go on at every stage? It will go up and down, up and down, up and down. First we went over limitation, then we came back, then we heard.
The question as to whether the award can be implemented.
Yeah.
That is also left open.
Yes, that's so. Of course.
No, that's not the case. I'll just
is it a case for 136 that for 20 years these people will go on, the amount due is 250 crores. I have a suggestion. Let them deposit 250 crores in court. Then go on litigate. I am going up and down. How many times will I do that? 250 crores is due to me from 2005. These are foreign awards. There are 3 awards, Quantum award, main award, etc., etc. And this going up and down is a question of law. Is it a case which should be heard by the High Court against an order of admission? Yes.
Listen, absolutely every submission made is incorrect. I will just tell you straight.
So why don't you first say where did the money come from? I want to know that.
I don't owe him a brass farthing. Now, number 1, I am not party to the arbitration agreement. Number 2, I am not a party insofar as the arbitration proceedings are concerned. He doesn't implicate me in the arbitration proceeding. Number 3, I am not a judgment debtor under the award. I am not any of these. He comes forward and he files his present petition. In the present petition, for these three reasons which are indicated to the court, I take out a chamber summons. That chamber summons is at page 310 at 312. Look at 312. I'm a complete stranger. I'm not a party to the arbitration agreement. I'm not a party to the arbitration proceedings. I'm not a party to the final award. So I take out a chamber summons at 310 with a prayer at 312. Please see that this honorable court may be pleased to delete. Yes.
High Court has held the appeal to be maintainable. These demerged entities are owned below by the judgment debtor to the extent of 98%.
There is no reason assigned by the High Court.
Yes,
And I have 6.1, what High Court says, High Court reproduces the prayer clause in the arbitration petition.
Yes.
And then says, the prayer as made thus indicate that the appellant seek enforcement of the aforesaid award as well as the execution against all the respondents.
Yes.
Therefore, maintainability is decided.
And I am going to show you what
I understand. Right.
If he is not a party to the agreement and party to the award, arbitration proceeding,
yes,
that should have been reflected in the order.
Will not kindly see 6.7. 6.77.
Page 16 of my list.
No, there is nothing.
6.7 will not for the same.
Appeal lies from an order refusing to enforce a foreign.
Under section so appeal lies from an order refusing. Enforcement will also take within its compass the execution.
No, not about the maintainability of the appeal. Maintainability of the appeal against them.
That's correct. That's obviously that's the only point. That's the only point
that dealt with. There is that issue which is now argued that we are not party to the agreement, not party to the award is dealt with under the impugn order. So,
I want to just show one.
Just kindly appreciate. Just kindly appreciate.
Yes.
The appeal is held maintainable against this party, but but the court has not said that you start paying today. It will be held ultimately in the appeal when it is decided.
File a response. There is no difficulty.
Yeah. Can I just show how dishonest this case is? Would the Lordship just turn to that page? Just see one minute.
We'll examine the dishonesty.
Can you just show only one document?
Yes.
Kindly turn, my lord, to volume 2, page 755. See how dishonest this case is.
Yes.
755.
Whose case?
The other side's case. I'll show you, my lord. That's why I said 20 years have gone by, my lord, and I won't get a farthing.
750?
755.
Yes.
Your Lordship will find at 753,
yes,
I have started giving reasons why 2 to 4 were to be implemented. Kindly turn to 755 ground C.
Yes.
Respondent 4 is the holding company of 2 and 3, which owns more than 98% shares in 2 and 3. In fact, respondent number 4 along with 2 holds 99.96% of E-City Entertainment. Given this control, R4 in conjunction with 2 and 3 were involved in facilitating the improper diversion of assets from E-City, which is the JD, to respondent 2 and 3 with the intention of frustrating the foreign awards. This is the position. Now, let me answer Justice MISHRA put to me. In other words, the High Court is only saying that in the appeal they are proper parties. That's about all. High Court is not saying that I am today fastening liability on 2 and 3 or 4. Now see without that part.
Paragraph 7, page 20.
Just turn to paragraph 7 now for 1 second. Yes. Now just turn to page, Lord, 20 para 7.
No, but someone who is not a party to the.
Can still be a proper party.
Can the award be enforced against?
Undoubtedly. Lord, two things. One.
We need to examine what we are.
Yes,
No.
and whether this appeal is.
One minute, please. Lord, Lord, please allow me to reframe the question. Whether, Lord, he will ultimately be held liable to pay under the award in this appeal is left open. Today, the court has only said that you are a proper party on account of the allegation of diversion. Correct. And Lord, let me answer one more thing. Suppose I go to court and say, my friend is the JD, he has transferred everything to him, and therefore in an execution I will add him. That's all there is to it. It's all left open.
Just kindly see paragraph
Para 7.
All strikes and contentions, all left open.
Just turn to this. Would you lordship see para 7?
Just one.
Yeah.
What we propose.
Just 1 second. Para 7, page 20. The judge is conscious. The division bench is conscious. Page 7, page 20, para 7. In our view, the objection of 2 to 4, Mr. Divan's clients, Mr. KAROL has it?
Yes.
Responded to the maintainability of the appeal filed for challenging the judgment, refusing to recognize is turned down. It is held that the present appeal as filed is maintainable against all, which means that they are proper parties to the appeal.
Yes.
There is no finding. Next slide. Accordingly, the appeal is admitted against all. It is clarified that while the issue of maintainability, the court has not gone into merits. That is not, are you liable, are you transferring? My lord, Mr. Sindhu, last portion. Last portion.
Yes, and who were the parties in the original proceedings?
So what happened was this.
He joined us.
No. The original party, my lord.
No, this judgment of 24th October, where is this judgment?
So that's at page 543.
24th October, my lord.
543.
Impugned before the High Court.
That was, my lord, the single judge.
We want to see the parties.
Yes.
Yes. 543.
543. And
543.
there are these 3 chamber summons which I.
Side along with the main matter.
Yes.
One minute.
Where are the parties in this?
My lord, 543.
543 and others.
And others. All right. My lord, I will, your lordship will find that, my lord, at 543 and 544, your lordship will get an answer.
What we propose.
See 544 middle, my lord. IMAC seeks a direction to enforce and execute the arbitral award, the 3 of them, has decreased in its favor against all the respondents. That is, my lord, those 3. Those 3, my lord, babies of the parent pursuant to the demerger. So they are parties there. They succeeded before the single judge. That's why I went in appeal. They succeeded.
But what is the finding of the single judge?
The single
Maintainability. What
Yes,
is
in my favor.
Single judge said, my lord, they are not parties, therefore you can't proceed against them. Simple. I went in appeal and say, I am entitled to proceed, therefore you hear them. The High Court will say, we will hear them. It's not a question of deciding.
In the original list, they are a party. In appeal, they have to be a party. They cannot be deleted at the stage of an appeal.
Now let me tell you, lordship, one more thing. Now, one more.
Mr. Diwan,
Last submission.
Mr. Diwan, if you were a party before the single judge,
You have to be before.
That's simple. Can I just simply explain it? Because I think this requires a hearing, but I'll answer the
the High
question.
Court,
Yes.
you are a party and you have won.
No.
How can you say that in a
I should not be a party. That's what I wanted to say.
It's exactly the incorrect impression projected. So now let me.
Not incorrect.
No.
It is on our query they have.
So I was not a party before because the single judge allowed my application.
That's all right.
Me as a party.
So that petition is in question.
It as a party.
We'll hear
Yes.
some more time.
Yes.
What we'll do is,
Yes.
Mr. Rohit, can you file your response in 2 days' time?
Yeah.
Today is Monday.
Yeah.
2 days time, can you file a response?
3 days not there.
Response is only whether who was party or
Ah.
some pagination.
Yeah. You know, I just said we'll do that. I'll do that.
And we'll keep it as part heard on Monday because we have this combination sitting on Monday.
That's end of the board Monday.
End of the board, we'll
Yeah.
keep that.
No problem.
But not
Can circulate
on
a short
Friday, my lord, at the end of the board.
We are-
Not this Friday, like coming Friday.
We don't know what is going to be the combination then. Monday we are.
All right, Monday. No problem. Monday, end of the board.
Maybe circulate a short note.
Please do that.
I'll do.
Yeah.
We have heard the parties at for some time. List, subject to the permission of Honorable Chief Justice, list on dash at 2 p.m.
Great. Thank you.
Let's give that report.
I'll do that. 2-page note. I'm surprised on this. I am a party in the original list. How can I be deleted in a week?
Next Monday, right? Subject to the chief.
Yes,
Yeah.
correct.
Great.
No, Mr. Dewan, it will be there because that DA matter is there.
No, very well, no problem.
Fine. Grateful to my lord. Very good.
The High Court has transferred the trial. The High Court
Yes.
The High Court has transferred the trial. It considered 6 petitions together. My trial is over. If your lordship can you see page 33?
Notice.
So grateful. Under the status quo.
You go and inform the transferring court that my trial is over.
But I will.
Why you come here?
Still in that they have put it.
Okay. Status quo has been.
So great. Let the status quo be there.
बोल तो दिया है.
Already.
So great.
So great.
Well, this was a tender matter. The lordship asked both parties to circulate notes and compilation.
Yes.
I have done that. If the lordship will take the.
That Navratna matter, no?
Yes. This is the case, Lord, relating to signaling equipment for the railways. It's very important, Lord, equipment. Now, Lord, I am L2 and L1 is another government corporation called RVNL. It is my case, Lord, that L1 is disqualified under the tender because it does not fulfill the eligibility. Why do I?
No, Mr. Rogi, we'll be very candid. We'll tell you, you are an uphill task.
Yeah, I know that. I will try and convince you.
But it is not the term of that, it cannot be subcontracted, it is not one of the terms.
Right. So.
The High Court has interpreted the contract.
Even this contract allows subcontracting.
If you don't mind, please.
Kindly have your seat.
Now, my lord, your lordship is right. Now let me straight away answer the question. If I tell my friend, you go and execute this job, with your intellect you execute the job. He comes back, my lord, and says, I have not executed the job with my intellect. I have given it to 3 of them. 1/3, 1/3, 1/3. They have executed the job, and this is the result of 1/3, 1/3, and 1/3. And therefore, I am, my lord, entitled as, my lord, qualified. Now, firstly, my lord, even if it is not prohibited, if I ask you to do a particular thing, then you jolly well do it till, my lord, there is a provision that you can sublet. That's one. Second, once he has given, my lord, certificate of experience, he has given certificate of experience to 1/3, 1/3, and 1/3. Can he claim the experience? If I have said that, my lord, I am giving you and you are the experienced fellows, can I take that experience? How is it possible? Now see, my lord, 3 provisions.
Now that experience certificate, perhaps you were not there. Yes, you were not there. Okay, you were there. And we, my lord, in fact, pointed out one clause of that.
And now I will I will now point out not the same clause. I was told that Justice Mishra pointed out the clause. I will now answer that. Just 2 or 3 documents.
And certificate, you see, he was doing work for and on behalf of them also.
No.
Only
Just bear with me.
I think we can do it.
Allow me to say.
Thank you.
Right.
Big one. Thank you.
Lord, we have checked up the law. There is an express statutory bar in the Act itself, which bars provision of Offenders Act. 20 capital laws, and there is a recent judgment of this court also. There is a judgment. There is a recent judgment of this court also, which says that it cannot be done in laws.
How do we help you?
No, my lord, the judgment will help me. You see that?
No, he says it is not helping you.
No, that's help. It is paragraph. Lord's paragraph 23, my lords, I would like to show to paragraph 23.1, my lord. They are given the reduced to the fine.
Less than minimum.
Yes.
Same
In Probation of Offenders Act do not apply. Here, sorry.
And that is the law which is settled for quite some time.
Yes, my lord.
That less than minimum can't be.
Yes, here they frame it two questions.
Not time to examine whether 360 CRP.
My lord, that has been expressly statutory barred under section 20AA of the Prevention of Food Regulation Act.
But
and that judgment clarifies that point.
I also had recollection.
Yes,
it can't be.
But here is since 1976 into the
How to help you? You tell us.
That's why I am showing, my lords.
We are willing, but
Yeah, this judgment is helping me. This judgment finally says that they taken over, released on the
which para?
Yes, my lords. My lords, can I, what questions framed here, can I say that directly I would like to take?
Directly.
Paragraph.
Directly.
Because we will also directly pass the order.
Yes, my lords.
Once you show us
paragraph 52, my lords.
Paragraph 52.
No. I will come to the paragraph 58, my director.
There is nothing.
Hmm. 60.
At this plea of conscience has been made to dispatch the order issuing the notice being limited
Just one.
in this
60.
52 and this one. Here, in this case also, my lords have issued notice limited to the quantum, my lords, and my lords have said that looking into this act, so fine was imposed and my lords, the answer to pair 60 is in pair 53. That is because there were 2 reports in that case, and the Honorable Supreme Court in an earlier case has held when there are 2 reports and there are 2 contradictory reports, then this court can do it.
I mean, that can't be the answer.
Yes, lords, that is
once when the court holds him guilty, then that earlier report will go on.
I leave it to your lordships, but
that it would have helped in conviction or acquittal. But when it is conviction, then 53 will not apply.
But that is in the case. That is other thing also here is offense.
Because this was converted to fine.
Yes, sir.
Because in this 20AA amendment was introduced.
Yes.
In 2006.
Yes, my lord.
And it was repealed in 2006.
Yes, my lord. Here is my.
For any offence which is committed between 76 to 2000.
Yes, my lord. They cannot be applicable.
No, then it is applicable.
Yes. That particular year you cannot applicable to.
But in your case, offence is of 4th August 2007.
7, my lords, right. That's why
this food safety cannot be applicable.
Food Safety Act, it will be applicable, my lords. In there, fine is you can reduce to the fine, my lords. That's why then it is amendment in 2020 is there. Then in particular period you cannot apply. This judgment is saying. Here in my case in 2007 and section 57.
What was the sentence? What was how did the statute read?
Yes, but I may just let the record state. The Repeal and Savings Clause in Penalty Act was enacted on 5th of August 2011. So your lordships, when in this judgment has held that till that time Prevention of Food Regulation Act held the field. Probation of Offenders Act will not apply.
We are not in probation now.
But it was after that.
After that. It was after the offence is of 2007. That the new act came into force on 5th of August 2011. And there is a notification to that effect and the act itself says so.
अरे भाई हम इनको प्रोबेशन पे नहीं छोड़ना चाहते, सेंटेंस को फाइनली रिवर्ट करना चाहते हैं.
Then you not section 57. 57.
दिखाना.
So, but this came into effect in 2011.
Yes, my lord, 5th of August 2011.
What was the provision between 2006 to 2011?
Lord, Food Regulation Act was enforced because the Repeal Act section.
But this, in our judgment,
that is, my lord, that is the anomaly. That is the anomaly. Because the Act is of the year 2006. Act is of the year 2006, notified in 2011. Notified in 2011.
Then the old Act was continuing.
Yes, that's I did not research it. Section 97 was introduced on 5th of August 2011 by government notification. So, are you sure that notified? Yes, sir. The Act says so.
57 लगेगा क्या?
So 15 penalty 2011. The repeal was repeal. Penalty 57.
You have been convicted for under 57.
I am convicted under my lord's old act. It is 57 in subsequent act. But I am convicted in 16A of privatization of food.
Reading all the act and then we'll take a turn from other.
Sorry.
You prepare a note as to what was the provision under the old act and under the.
I will make a note and
I'll
make a note and
try to make out a case.
Yes,
so that we are convinced that we can reduce.
Yes, I will do my lord.
And convert into a fine.
Yes, I will make a note and.
Because if you fail to convince, we are not the sufferer, you are the sufferer.
Of course, sir, that's of course. Highly obliged, man. Deeply obliged. Highly obliged.
Please, Lord, I made a calculation chart. Lord, I made a calculation chart. Lord, may I suggest a buyer media?
Calculation में कितना बनता है?
Yes, Lord. Understanding. Lord, your lordship may increase, Lord, the rate of interest. In which case, Lord, even if your lordships were to, Lord, exclude, Lord, those 3,700 days, he will get interest, Lord, equivalent to the enhanced compensation itself. So that should not meet the ends of justice, Lord, in this matter.
What is the amount?
Lord, 4.56 lakhs, Lord, was the enhanced compensation. 7.5% interest, Lord. Your lordship will make it 9%, Lord. I've given the calculation as per 9%. So, Lord, the third, Lord, column, even if, Lord, those 3,700 days are excluded, he will still be entitled to, Lord, 4.55.
What you are suggesting is that the rate of interest is the total amount works to 3,79,000.
Yes, Lord. If at the
as per 7.5.
As per 7.5.
I'm saying
lordship enhances it, Lord. So that can, Lord, that will remain excluded, but if, Lord, 4.5, Lord, was the enhanced compensation, he'll get the exact amount of interest also, Lord.
No, he'll get more. No?
Almost the same, Lord. 4.56 is the enhanced compensation. At 9%, Lord, will be 4.55, Lord, lakhs interest. That should, Lord.
This appeal is delayed by 3,700 days.
Lord, restoration. There was a delay of 726 days, Lord, in filing the appeal. That was excluded by the High Court. In fact, Lord, there were two orders passed by the High Court. There was one order whereby 3,700 days was also excluded. But, Lord, that order came to be passed. Lord, erroneously, the matter was placed twice before the court for, Lord, restoring the matter.
So, what you are suggesting is that we, as far as the period 726 is concerned and 3,700 is concerned, we exclude this period for the purposes of computation of interest. But if we were to increase it from 7.5% to 9%, the figure would remain same.
Yes, 4.55 lakhs, Lord, is the interest. This is the interest. Yes, so 4.56 lakhs, Lord, is the enhanced compensation. The interest on this enhanced compensation, Lord, even after these exclusions, will be 4.55 lakhs.
So 4.06 plus 455.
Yes, Lord.
Principal amount plus the enhanced amount of interest, plus the interest at the enhanced rate.
Yes, Lord. So this is the only the interest, Lord. 4.55 lakhs is the interest on the enhanced amount for 23 years, excluding those, Lord. Yes.
In today's date, I think that is satisfactory. The period of delay of 726 days, no interest would be payable for the period of delay, that is 726 plus 3,700 days in preferring the appeal, stroke getting the appeal restored after dismissal. However, the interest is the rate of interest is enhanced from 7.5% to 9% per
Well,
in the peculiar facts.
well,
Thank you.
wait for the
Yeah. Yeah. Cement charge, cement.
Yeah.
Acha. Yes, were you able to? You were able to talk to her independently?
Yes, Your Lordship, I did talk in my interactions with the complainant's daughter, the respondent, the respondent woman. I had talks with her where she stated that she had been in a consensual relationship, and though she had met the accused while she was still a minor, she has not at all felt coerced throughout the course of the relationship, and the decision to decide to get married was a consensual decision made independently by this one.
And she's happily residing in.
She's happily residing, and she also has one feels supported by her husband. In fact, she has plans to pursue web designing. That and her husband is fully supportive of her pursuing an independent career and education.
Milords, there's a judgment also, Milords. Sorry, I'm interfering. We can pass it through, Milords. This
Final order today.
Okay.
We are recording their statements so that
Please,
they are not required to come again to this court.
Very well, Milords. Very well.
Some other day we'll pass final order.
लिखिएगा मैम नाम लिख लीजिएगा as on our asking has individually interacted with the petitioner
R2 respondent 2
petitioner number
there's only one petitioner, Milords.
With the respondent number 1.
Sir, Your Lordship,
respondent number 2 is the
respondent number 2. Respondent number 2. Full stop. We are informed that at this point in time, the parties, that is the respondent number 1, 2.
2 Milords.
Respondent number 2 is happily residing with her husband, with whom she has had consensual relationship prior to her marriage. Such relationship was without any coercion, fraud, or promise. Even after marriage, her husband is taking good care of her, and she intends to pursue her higher studies, in which her husband, of which her husband is supportive of. The victim is also present in court. You understand English?
Yes, yes, sir.
And you confirm from who has been who's present in the court, reiterates such statement. Parties need not remain physically present in the secretary. They can join the proceedings. They are allowed to join the proceedings. So, please move.
Milords, interim is till today. Sorry.
Husband, who's also present in court, submits that he is married the petitioner. He married that he's happily married to respondent number 2, and shall continue to maintain her at all times.
If my lords is adjourning, my lords, one last request is the interim to continue because trial court keeps asking it's only till today.
एक order था जिसमें हमने amicus लगा वो करेंगे एक draft list on कर दे.
Obliged, my lords.
Thank you.